Good morning, everybody. Happy Monday. Welcome to TCF Live. Apologies for a delayed start this morning. We had some things to handle behind the scenes. It is a slow start in Courtlandia today, but we'll get going with Brian Oakley and see what's going on there.
Discuss this matter with the prosecutor, and the defendant is in agreement to pleading guilty to the harassing phone calls. She pledges that she will not call her grandmother again. And if the judge allows, if you allow, Judge, she'll take it under 771.1, which would be the delayed sentence.
And was there a time frame discussed between you and the prosecutor counsel?
It's a 12-month time frame that she offered, Judge.
Thank you. All right, Ms. McLean, did you discuss, can you activate your camera, ma'am?
Yes, sir. Can you see me?
I can. Did you discuss your rights and options with Mr. Graziani?
Yes, sir.
Do you understand those rights and the options they present?
Yes, sir.
All right. And you understand, do you understand the possible penalty for the charge?
Yes, sir.
Understanding all of this, are you pleading guilty to that charge freely and voluntarily today?
Yes, sir.
Counsel, if you would like to voir dire to get the facts to satisfy the plea, February 9, 2026 is the date on the file.
Hey, thank you, Judge. Ms. McLean, is it true that on that date that you made numerous phone calls to your grandmother?
Yes, sir.
And did she indicate she didn't want to talk to you?
No, sir.
No, we spoke earlier, and she wanted you to stop.
Yes, sir. She did want me to stop.
And but you still continued calling her. Is that correct, Ms. McLean?
Yes, sir.
Okay, Judge, I'm satisfied.
I'm satisfied as well. All right, I will accept the plea. And let's see, you're in Dallas, correct?
Yes, sir.
All right. Are you working?
Yes, sir.
Where do you work?
Say it one more time.
Where do you work?
I work for Gardner doing security for Google.
Thank you. All right. It says, I got paperwork here that says you got a file from 2025, malicious destruction of a building. You're on probation.
Yes,
I
sir.
indicated
That's
that
with my
to Ms.
grandma.
Vanderman.
Okay.
Judge,
And it looks like you were just placed on probation this January. Is that right?
Yes, sir. That was with my grandma.
Yeah. How long is your probation? Was it 12 months?
Yes, sir. And restitution has been paid in full.
Yeah. It looks like you already paid off all the money. You just got to stay out of trouble for 12 months, right?
That's a fair deal.
Anything else you got to do for probation?
None that I'm aware of. I do need to follow up with Mr. Grant
Okay.
after this court hearing.
Yeah. Make sure there's no other stuff, no other boxes you got to check to be successful on probation.
Yes, sir. Will do.
All right. Anything else you want me to consider before I sentence you on today's file?
Judge,
No,
she's
sir.
been gainfully employed. She's got an excellent work record. She had a very difficult upbringing. Homeschooling has been thought that it's a lot of people think homeschooling is great. It should actually be a hybrid program. That's my little assessment. But as a result, Miss McLean did not have much interaction with other folks during her troubled childhood, and as a result, she became quite dependent on her family, her mom, and her grandmother. And as a result, it created these problems. And she's gainfully employed. She makes almost $30 an hour. She went to Wayne State for 3 years, and I think she's got a bright future. But like all of us, she may need some counseling, Judge.
Okay. All right. So my concern is it looks like the incident date on this one is 2/9/26. It was after she was sentenced. This could be a violation of probation.
Judge, I realize that. I still believe that she would qualify. You know, I discussed that with Miss Manarino, and she indicated that she could still qualify for 771.1.
Okay, but that doesn't mean she won't have a problem with the probation file.
Understood, Judge. Understood. I explained.
Okay. All right. Okay.
I think quite frankly, all these, it arose out of the same incident of anger and, you know, a little bit of stupidity. But like I said, Miss McLean's got a very bright future.
Okay. All right, Ms. McLean, anything else before I sentence on this file?
Yes, so when you said that it could be a violation, how does that work now, if it is a violation?
Anytime we
with
put
the-
somebody on probation, one of the terms of probation is you stay out of trouble, no further offenses. So if you were sentenced on January 6, 2026, but yet this charge came up in February, whoever sentenced you, I'm assuming it's Judge Martin?
Yes, yes, sir.
Okay, so Judge Martin could violate your charge I'm taking the plea on. Whether or not she does or not, I have no idea. I don't know what conversation she had with you when you were sentenced. I'm just telling you.
So
that-
wait, I have a question, Judge. That incident for February 9th, I was already in Dallas, Texas, and had no communication with her. I did communicate with my grandma starting from Halloween up until my court date in January, but I never made contact with her in February because I was
Okay.
already in Dallas, Texas on January 10th.
Okay,
It
so,
could just be because of the filing with the delay, but I can guarantee you I didn't have contact after
Okay.
January 10th of this year.
okay, well, if that's the case, you probably won't have any problems with your probation file. I just have to warn you because my incident date is February of this year.
I understand. And
Okay.
with that being stated, with the probation hearing, if it is a violation, how would that then result for me?
That's on that file. It's not gonna change my file at all.
Judge,
Okay.
if Judge, I apologize for interjecting. If you don't mind, can I speak to Miss McLean again? Because I explained some of these things and I obviously didn't do a good enough job, sir.
Yeah, and based on what she's telling me, it might not be a problem, but I just have to.
I don't think it is either, Judge, but I simply want to clear
Okay.
that, you know.
All right,
Thank
take her
you.
back in the breakout room.
All right, I'll put you back in.
Yeah. Yeah. Ms. McGoldrick, come on up to the podium for me. You're here today for a dangerous dog misdemeanor from August 5, 2024. The prosecutor wants me to dismiss that. I'm assuming that's all right with you. Okay. That's the good news. Unfortunately, the bad news is you owe us money on some other stuff. So let's see if we can talk about that.
I did some emailing.
Are there any other files there? Hold on, man. Hold on. Are there any other files with her name on them?
I don't, I can look. I looked earlier.
Judge, what's the last name, please?
First name Cynthia, last name McGoldrick,
MCG.
MCG. Looks like she's got 4 or 5 files in warrant status, but they didn't send the files in.
Yeah, there's no other files for it again.
All right, so I've got a 2019 Van Buren Animal at Large. 2019 Van Buren, I'm not even sure what that stands for. Something with an animal charge. 2 charges, Van Buren 2021, unlicensed domestic animal in violation of technical requirements. And all those are in warrant status with money due. All told, because not only those, we've got some other files that you owe us money on. All told, you owe us over $2,000. Okay. Since when? Because as of April 7th, we've got no record of any payments.
I already made about 3 payments of $200.
When?
The 10th of.
Okay, so my records don't reflect that. You sure it's not some other file? Okay. So how much are you making?
I make
No, payments, how many?
$200 a month. I think I've made 2 or 3. And I know I started off with the $50 one that you have to do to get into the payment plan.
And when's the last one?
I just made one.
Like today?
Like 3 days ago, 4 days ago or something, just to make sure it was before the 10th, sometime before the 10th. I never got something that said what my payment plan was going to be.
About the only way that happens is if you come in here and paper to leave. So here's what I'm gonna do. Today's file is dismissed. Go downstairs, make sure they have record of the payments you think you made and get your plan when you walk out, you have paper.
Yeah, I'll send it.
All right, go downstairs. You're welcome. Morning, counsel.
I'm ready, Judge. Thank you.
All All right. Well, I was saying good morning to you, but Mr. Graziani's online too. There's Miss McLean coming back in.
I'm here,
Alright.
Judge.
All right, are we ready for sentencing on today's file?
Yes, sir.
Judge.
Okay, so I'm gonna delay sentence for 12 months, which means no further problems today, from today forward. I'm also specifically ordering no contact with your grandmother. Am I pronouncing your last name correctly? Ivy?
Yes, sir.
Okay, so no contact, no phone calls, no social media contact, no emails, none of that stuff. No contact.
Yes,
Understood?
sir. Yes,
All
sir.
right. Court costs are assessed in the amount of $300. Can you pay that online today or do you need some time?
You want me to pay $300 for restitution?
Not restitution, court costs.
No, not today. We'll do a
Tell me how
payment
much time you
plan.
need.
I just paid $1,000 for restitution, so give me a minute. I do have to pay rent and utilities here in
Within
Texas.
30 days?
Give me 60. It'll be paid in full though.
Thank you,
All right.
Judge. Thank you.
So we're not gonna send you anything on that. I'm just telling you, you owe $300. I'm giving you 60 days to take care of it.
That's a fair deal. Thank you, Your
Okay,
Honor.
so you don't get any reminders from us.
Yes, sir.
Okay. That
Thank you,
takes
sir.
care of it, Mr. Graziani?
Yes, Judge, thank you so much.
No, I
Thank you
know.
very much.
He's paid like $550. The first time, just like she said, I paid $50 for the.
Right.
They didn't remove no warrants.
Okay.
She paid a $200 payment in March, and then she made the $300 payment.
Who's working the cash register today, do you know?
Don't even know.
I saw Grace, Jerome up there.
Why don't you have Jamie walk that file down and hand it to cashier and say Heather's got it online, that she's paid $550, even though that paperwork doesn't reflect it. What do you got?
Just adjourn, two little directions.
Did
Yeah,
you just?
she said right there.
Mohammed Jerry. I already.
How are you? Good. How's business?
I'm real slow, but that's okay.
Yeah.
It's a roll.
Yeah, you're at the point where slow's okay. Yeah. Yeah.
I
Yeah, just enough to keep your mind sharp.
want to, I don't plan to head, this way, but I never have.
Right.
And it's always worked out.
Right. You're not gonna change now.
Until I have.
Yeah. Well, I was talking to a guy last week, and I said, I'm going to retire from this job, but I'm going to keep working. And that's the nice thing about that bar card, right? If you want to work 3 hours a week, you can find a job to work 3 hours a week. I'm just not wired that way to just stop, right? Like I said, it gives you a reason to get dressed in the morning, get out of the house, exercise your head a little bit. No, I think that's one of the greatest things about our profession is you can work as little as you want or as much as you want.
Guys, they focus on making it that big. I'm not one of them.
Yeah.
I'll enjoy the game.
Yeah.
Do you want the 8:15 again for May?
Sure, but one day.
May.
All right, good morning once again, everybody. TCF Live. It is a Monday. My name is Dan Soul. I will be your guide through Courtlandia for the next few hours or so. Let's go down to Florida. Wade Mercer, say good morning to him.
Assistant Public Defender. I want to ask the two prosecutors in the courtroom to introduce themselves, make sure you can see and hear them.
Jake Mitchell on behalf of the state. Lance Bell on behalf of the state.
Thank you. And Corporal, can you see and hear all of us at the courthouse?
Yes, sir, I can.
And have you had a chance to play your first appearance video?
Yes, sir, I have.
Thank you. We have Victor Hernandez. Mr. Ricardo, good morning.
Good morning, Your Honor.
Mr. Ricardo, would you please introduce yourself to Mr. Hernandez and make sure he can see and hear you?
Very well, Your Honor. Señor Hernández, mi nombre es Jordani Ricardo. Soy intérprete para que se pueda comunicar con el juez. ¿Usted me ve y me escucha?
Sí.
He can hear me and see me, Your Honor.
Great. Mr. Hernandez, you're here because you've been accused of one count of driving with no valid driver's license.
Señor Hernández está aquí porque tiene un cargo de manejar sin licencia de conducir válida.
The judge covering first appearances this weekend has already found probable cause and set you a bond.
El juez que estaba encargado de las comparecencias iniciales este fin de semana ya determinó que había causa probable y le fijó una fianza.
In addition to that criminal charge, you have a hold from the United States Immigration Service.
Además de ese, how much is the bond? Además de ese cargo penal, usted también tiene orden de retención de parte de inmigración.
The bond you were set this weekend was $750, but that's only on the state charges.
La fianza que le fijaron este fin de semana fueron $750, pero eso es solamente por los cargos estatales.
So even if you post the bond, you still have a hold from the Immigration Service.
Aunque usted pague la fianza, de todas formas tendría la orden de retención de parte de inmigración.
In fact, according to what I've been provided, not only do you have a detainer, a judge has already signed an order of removal.
De hecho, de acuerdo con la información que yo tengo, usted no solamente tiene una orden de retención, ya un juez firmó la orden de remoción.
So I'm appointing the public defender's office to represent you and asking that you listen to your attorney.
Entonces le voy a asignar al abogado de oficio para que lo represente y le pido que escuche a su abogado, el señor McDaniel.
Your Honor, I spoke to Mr. Hernandez. He's going to plead no contest to the charge as listed.
Su señoría, hablé con el señor Hernández, él se va a declarar no me opongo ante los cargos, tal como se le acusa.
He's sentenced to 3 days in the county jail, credit for 3 days.
Se le condenará a 3 días en la cárcel del condado con crédito por 3 días.
It'll be a $400 fine, which will be a civil judgment against his credit rating.
Tendrá una multa de $400 que será un fallo civil en contra de su puntuación de crédito.
Waive his right to a jury trial and call witnesses.
Está renunciando a su derecho a un juicio con un jurado y a llamar a testigos.
Understands that any plea can be used against him in immigration proceedings.
Él entiende que cualquier tipo de acuerdo en un caso penal se puede usar en su contra en procedimientos de deportación.
Thank you, Mr. McDaniel. Mr. Mitchell's at agreeable with the state. I'm sorry, Mr.
It is, Your Honor.
Thank you.
Gracias, señor McDaniel. ¿Y al Estado? ¿Está de acuerdo el Estado? Así lo está, su señoría.
Mr. Bell, any objection to withhold?
No, sir.
Y señor Bell, ¿tiene alguna objeción a que suspendamos el fallo de culpabilidad? No, señor.
Mr. Hernandez, any questions about that agreement, sir?
Señor Hernández, ¿alguna pregunta acerca del acuerdo?
No,
No.
no,
No.
no.
Is that the plea that you would like to enter?
¿Es este el acuerdo que usted desea aceptar?
Sí,
Yes.
sí.
Yes.
I'm going to accept your plea of no contest to the charge of driving with no valid driver's license.
Acepto su declaración de no me opongo ante el cargo de manejar sin licencia de conducir válida.
I'm going to withhold adjudication of guilt and sentence you to 3 days in the Jackson County Jail.
Le suspendo el fallo de culpabilidad y lo condeno a 3 días en la cárcel del condado Jackson.
But you have credit for the 3 days you've already served.
Pero tiene crédito por los 3 días que ya ha cumplido.
I'm also going to order court costs and fines of $400.
También le voy a imponer multas y costas del tribunal por $400.
Those court costs and fines will be a civil judgment against you.
Las multas y costas serán un fallo civil en su contra.
So I'm going to ask the jail to notify immigration that you finished your local charges and that you can be picked up by them.
Entonces le voy a decir a la cárcel que le notifique a inmigración que ya terminó con sus cargos locales y que está listo para que lo recojan.
Yeah.
And pursuant to their agreement with the state, what that means is they have 48 hours to pick you up.
De acuerdo con el acuerdo que ellos tienen con el Estado, eso significa que tienen 48 horas para recogerlo.
Do you have any questions?
¿Tiene alguna pregunta?
No,
No.
no, no.
Have a good day, sir.
Que tenga buen día, señor.
Thank you, Mr. Ricardo.
Thank you, Your Honor.
We have Jerome Davis III. Mr. Davis, good morning. Mr. Davis, I'm looking at a copy of a violation of probation warrant signed by Judge Garcia. It's a no bond warrant. What that means is you've been accused of violating the terms of your supervision, and there's a no bond warrant that's been signed. What I want to do this morning is I want to go ahead and arraign you because I want to get you a lawyer appointed to represent you in this VOP if you're asking for one. Would you like to have an attorney appointed to represent you?
Yes, sir.
I'm going to appoint the public defender's office to represent you. Listen to your attorney, Mr. McDaniel, and we'll see if you have any questions in just a minute.
Your Honor, I'm going to enter plea of not guilty. Yes, to set this in the April 23rd court docket, and I advise him deputy attorney from the public defender's office to stop by and speak to him prior to that hearing.
Thank you. And Mr. Mitchell, anything, or Mr. Bell?
Yes, sir.
Mr. Davis, do you have any questions?
No, sir.
All right, sir. Wish you the best. We have Terryana Thomas. Thomas, good morning. Ms. Thomas, you're here because you've been accused of one count of possession of cocaine. Ms. Thomas, I've read the complaint, ma'am. There does appear to be probable cause for the charge. Ms. Thomas, I'm going to appoint the public defender's office to represent you for first appearance purposes. I'm going to ask that you listen to Mr. McDaniel, and we're going to address your bond or your release status. Mr. McDaniel, anything on behalf of Ms. Thomas?
Your Honor, she's on disability. We just asked for some kind of reasonable release option.
Mr. Mitchell or Mr. Bell?
Your Honor, we would just request a reasonable bond and that she be subject to random UAs.
Ms. Thomas, the allegations are much more complex than just a normal possession of cocaine. There's allegations of the driver switching twice. You're accused of being the driver at one point, you're passenger, then driver, then passenger. It's just kind of a little bit confusing, but in the probable cause cases, there's probable cause, I think. It's just not a super strong case. But the other person, I think, was arrested with the fleeing and eluding, and you're not charged anything regarding that at this time. But there's enough there to make me think that you shouldn't get a conditional release. I'm going to set you a bond. I'm going to set you the normal bond I would set. Mr. McDaniel, I have no problem with a cash bond given her history. Otherwise, I'll set a surety bond. What's your preference, Mr. McDaniel?
Cash bond.
Mr. Bell?
No objection to a cash bond.
I'm going to set you a $500 cash bond, Ms. Thomas. Your bond is $500 cash. You do have a condition of random urinalysis, Ms. Thomas. What that means, ma'am, is you can and likely will be drug tested, ma'am. So be aware of that. If you fail a drug test, that could cause you to go to jail with no bond. But Ms. Thomas, you'll get to use the phone in a few minutes, ma'am, to post the bond. The jail also will give you a notice for your court date, and that will be May the 5th at 8:30 a.m. May 5th at 8:30 will be your court date. Ms. Thomas, do you have any questions?
No, sir.
Have a good day, ma'am. Frank White Jr. White, good morning, Mr. White. You have a couple of different issues. The first is case 25-303CF. In that case, the circuit judge has already revoked your bond. In case number 26-54CF, you also have a no bond warrant for allegedly failing to appear at arraignment. Then from yesterday, you have 5 charges. So I'm going to tell you the charges, and I'm going to set a bond on these cases because you're entitled to a bond, Mr. White, but keep in mind, you've got 2 cases with no bond, 2 case numbers. So even if you post the bonds I'm about to announce, you still wouldn't get out because the other cases are going to hold you in jail. On the charge of fleeing or attempt, there is probable cause for all these charges. On the charge of aggravated fleeing or attempting to elude, your bond will be $50,000. The charge of resisting an officer without violence, your bond will be $5,000. Possession of cocaine bond will be $10,000. Possession of firearm by a convicted felon, your bond will be $50,000. Driving while license suspended or revoked knowingly, your bond will be $5,000. When you add those together, your bond from today, $120,000. But keep in mind, as I said, you still have no bond in the other cases. There is a condition of random urinalysis in the new bonds if you ever post it. Mr. Bell, any other requested conditions?
Yes, Your Honor. Under case 25-303, he was subject to random urinalysis. We're asking for the jail to drug test him.
So we need to get, if he's got a condition of random urinalysis on the other case, we need to get a urinalysis, Corporal, after first appearance, please. And please notify the state and defense by email the results of that urinalysis. I'm also going to give you a tentative court date, Mr. White. Now, this court date may change because they may just put it with your other cases' court dates. But in these new cases, your court date tentatively will be May 5th at 8:30. Mr. White, even though you've got no bond, anytime your bond status changes, you have the right to use the phone to contact friends or family and tell them what's going on. So you will get to use the phone in a few minutes, sir, to contact whoever you wish and let them know what's going on with your bond status. Mr. White, do you have any questions? Have a good day.
Okay, quick pause in the action because Wahoo put in the chat, I'm curious how many polyesters had to be slaughtered to make a suit like that. We were talking about the suit that the lawyer was wearing a little bit ago in Judge Oakley's court. So I took a screenshot of that. I fed it to Grok and asked it how many polyesters had to be slaughtered. And Grok said 0 polyesters were harmed in the making of that suit, but about 47 petroleum dinosaurs died screaming in the 1970s, so some guy could look like a walking leisure suit from a bad cop show. Rip to the fossil fuels that gave their lives for that shiny crime against fashion. So there's your answer, Wahoo. Let's get back to court.
Just a second, I might be able to see if he's on the pretrial for the 21st.
We have Jaden Durant, 120, what's that in the new cases? Give me just a second to finish this note here. Mr. Durant, good morning. You're here because you've been accused of domestic battery. Mr. Durant, there is probable cause for the charge. It's your second such arrest in a little over a year. Mr. Durant, the prior case was dismissed. I did see that at the victim's request. The alleged victim in the prior case was your sister. The alleged victim in the current case, I believe, is your mother. So, Mr. Durant, I'm going to appoint Mr. McDaniel's office to represent you. I'm going to ask that you listen to Mr. McDaniel, and then we'll see what the state's position is also. Mr. McDaniel, anything?
Your Honor, he works at the Family Dollar. We just probably just ask some kind of reasonable release option. And just keep in mind, I mean, I tell people all the time, don't call the police. I mean, he called the police because his mother with a hammer was trying to break down the door, you know, and I understand that, you know, who they arrested, but, you know, it's.
Do you really tell people don't call the police?
I do. Yeah, I do. Absolutely. Because I mean, just because of this instance right here, you know what I mean?
You know what's interesting is when I went and read the other complaint, Mr. McDaniel, he actually is the one that called law enforcement at that time too.
I mean, I'll take a general view as well. I ain't gonna say it on the video.
Yeah, and I just thought it was interesting that both times he called the police. I don't know that I've seen that before. So, Mr. Durant, let me ask this question. Obviously, there's going to be a condition of no contact, and I don't know that I would consider a conditional. I would consider a conditional release. I don't know if I'll grant you one, but I certainly would consider it. But before I even can think about it, I've got to know if you have somewhere else you can live on a temporary basis, other than where your mother resides at. Do you have somewhere else you could live?
Right now, he don't have a positive place
Okay.
that he. You know, I think he thinks enough time he can find some place.
Well, if I can call someone real quick,
Okay,
then
it's no problem. Mr. Bell, anything from the state?
Your Honor, we'd just be asking for a reasonable bond and no contact with the alleged victim or the property.
So, Mr. Durant, I'm going to set your bond at $2,500 cash or surety. You have a condition, no contact with the alleged victim or that property. Mr. Durant, if you find a place to live and if we can verify it and if you know it's a reliable place, then I might consider a conditional release because as Mr. McDaniel pointed out, or as I may have said myself, the prior case was dismissed. So essentially you have no criminal convictions. So you might be a conditional release candidate, but I wouldn't even consider that unless you had a place to live. And this is, you know, it's concerning that you've got 2 arrests. I have pointed out though that you were the one that called law enforcement both times. So Mr. Durant, you'll get a chance to use the phone in a few minutes. If you post the bond, you'll be released. If you're not able to post a bond, then Mr. McDaniel may bring you up in the next few days if you have another place to live. Mr. Durant, do you have any questions?
no, sir.
Have a good day, sir. Let's give him a notice, please, for what date? April 27th at 9 a.m., please, Corporal.
Yes, sir. Got it.
Thank you. We have Deron or Darren Gardner. Mr. Gardner, good morning. Mr. Gardner, you're here for first appearance. You have 4 charges. You've been accused of 1 count of fleeing and eluding. That appears to be the 3rd-degree felony version. Tampering with evidence, also a 3rd-degree felony. Then you have 2 misdemeanors. They are resisting an officer without violence and possession less than 20 grams. The complaint says there may or may not be a DUI charge forthcoming. So as of right now, you haven't been charged with that, but the complaint does make a note that potentially could happen. So, Mr. Gardner, I've looked at your criminal history. There is probable cause in the complaint. You've got a very long criminal history. You've been to prison twice, according to the Department of Corrections website. Mr. Gardner, I want to appoint the public defender's office to represent you for first appearance purposes. Let me listen to the attorneys. I think you're entitled to a bond as far as I can tell. Let's make sure I'm not missing something. Mr. McDaniel, anything on behalf of Mr. Gardner?
No, Your Honor.
I want to
Mr.
speak.
Bell.
I want to.
I'll give you a chance in just a second. Mr. Gardner, I'll give you a chance to say anything you want in just a second, okay?
Not bad. Yes, sir.
That's okay.
Your Honor, we'd just be asking for a reasonable bond and subject to random urinalysis.
Thank you. So, Mr. Gardner, I'm glad to listen to anything you want to tell me for bond purposes. I would tell you, don't talk about what you've been accused of. We are being recorded. So I don't want you to go into the allegations against you because it could end up hurting you. But if you have a question or if there's something you think I need to know for bond purposes other than what I've already said, certainly feel free to ask a question or let me know anything like that.
Your Honor, I was taken into the hospital last night. In the process of everything that happened last night, the officer explained that he had to bend me over, beat me up and down my back. I'm already going through procedures at the moment with Panama City vocational rehab for neck and back problems. This officer lied and didn't he called the ambulance from out of Chipley, Florida. He come to me and he just checked for my mom, said there was nothing wrong with my mom. They said there was nothing wrong. And I asked him to check my neck and he screamed, yeah, that they not want to do that. So when I got to here last night to the jailhouse, they offered me, they told him to take me to the hospital and get me checked out. Now they have me on medications. So I just wanted to let you know that, Mark, Your Honor.
Okay.
I'm sorry.
Yeah, the
I'm
complaint
sorry.
alleges that you were trying to swallow and eat the marijuana to keep it from being discovered, but he was able to do some kind of back pat. What's what the complaint says and recovered some of the marijuana out of your mouth. That's why the tampering with evidence charges there. But your criminal history is horrible. Your bond is $7,500 on the 2 felonies. That's each $3,500 each on the 2 misdemeanors. That makes your bond $22,000 cash or surety. And Mr. Gardner, you have a condition of random urinalysis. That's part of that bond. The jail's going to give you a notice for your court date. That will be May 5th at 8:30.
How much?
And keep in mind that random urinalysis condition. So, Mr. Gardner, any questions?
No, sir.
All right, sir. Wish you the best. Mr. McDaniel, that's everything I had on my first appearance list this morning. Let me ask Sergeant Campbell a question. Sergeant Campbell, on the out of custody returning upon notice, there was a misdemeanor case.
Yes, sir. It's actually
Willie McCrary, but support case meter, did they post bond and the purge?
Felony. No, it's a habitual. It's a felony. They just didn't put it on there.
Say that on here. Okay, so it's a felony
Yes,
charge.
sir.
Okay.
Yes, sir.
I assumed they had posted bond and made the purge also, but all right. So that's everything I had. Mr. McDaniel, anything else from the public defender's office?
I'll just off the TDO, I'll say.
All right, friends, once again, good morning. It's TCF Live. It's a Monday. My name is Dan. It's good to have you all here with me. Let's head back up to Michigan. Judge DeSanto.
Name for the record, please.
Randy Ramey.
Okay, and thank you for dressing appropriately for court. And counsel as to the pretrial.
Yes, I am pleased to report that we were able to achieve a resolution in this manner whereby the people now add an amended count to driving while visibly impaired. And it's still guilty to prosecute. We dismiss the original count.
All right, and so, sir, I'm going to have you please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this matter be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right, and you heard the plea that was placed on the record, correct?
Yes, Your Honor.
And as to the amended charge of operating while visibly impaired, how do you plead?
Yep.
You've gone over your advice of rights with your attorney, correct?
Yeah.
And you understand all of those rights?
Yes, Your Honor.
You also understand, sir, the possible penalty as a result of your plea, whether in this court, any other court, or administrative agency?
Yes, Your Honor.
Knowing all of that, do you want to continue with your plea?
Yes, Your Honor.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No, Your Honor.
Any immigration issues?
No, Your Honor.
All right, counsel, if you can please voir dire your client.
So, Mr. Remy, you were driving in the city of Riverview on January 9th, 2006, is that correct?
Yes.
And prior to getting in that vehicle, did you have an occasion to drink alcohol?
Yes.
And was that at the 10 penny? Or 10, yes, 10 pin, sorry.
Yes, I've been a train.
Yes. And do you consume the alcohol? Did you drive?
Yes.
And were
I need you to
you,
speak up, sir.
Yes.
and were you stopped by a police officer?
Yes.
And were you asked to perform field sobriety tests?
Yes.
And you admitted to the police officer that you did have a couple of drinks, correct?
Yes.
And you also acknowledged to him that when he asked if you felt intoxicated, you said a little.
Yes.
All right, okay. And you're asking the court to accept your plea of driving while visibly impaired as opposed to the original charge, is that correct?
Yes.
And you're doing that voluntarily, correct?
Yes.
Okay. Did you receive the blood results? As I was trying to get the guts of the file put back together because the report was all out of whack and in between some of these other pages. I did not see the blood. Oh, no, I'm sorry. Here they are. 0.150.
That's correct, Your Honor.
Okay.
It was a 0.116.
Okay. Are you stipulating the 0.15 for purposes of the plea?
We are, Your Honor.
All right. And it also detected potentially marijuana. I think that,
That's correct. And
please, just let me finish, please. And I don't know if your client had utilized it prior to driving or if it was residual from something else. So,
I know the answer to that question.
Okay.
And we had that conversation with the prosecutor. It was an old pen. It wasn't operative and he didn't have any that day.
okay, perfect.
That's the reason that they were willing to just dismiss the man.
Okay, very good. Thank you. Okay, and so the court does find the plea as knowing, voluntary, and factually accurate. The court will accept your plea to the amended charge, dismiss the original charge per the plea agreement. And sir, if you test right now, what is in your system?
I would assume marijuana, Your Honor.
Well, please don't assume that because I ordered you, well, that was just a few weeks ago, March 23rd. You were supposed to originally have been here March 9th, but it was adjourned for a scheduling conflict. So do you have any new use since March 23rd?
Yeah, I have my medical card,
When did you obtain your medical card?
April 1st.
April 1st. Okay. After you were already under the jurisdiction of this court. So let me just explain to you how that goes, sir. Okay. You did not have it prior to being under the jurisdiction of the court. So when the court orders not to have any, not to possess or consume any alcohol or drugs that are not prescribed, and somebody goes out and obtains their medical card while they're on bond, that's highly suspicious for a few reasons. Okay, it's highly suspicious for medical purposes. Now I'm going to ask this question, judging one way or the other, even though I'm sitting, did you obtain it from your primary care physician or your treating physician, or did you walk into a clinic and that doctor prescribed it to you?
Walked into a clinic, doctor.
Okay, so again, your treating physician. If it's a need for medical purposes, then we need a communication from your treating physician. You don't even have to go get the card. I just need something from your treating physician.
Gotcha.
So moving forward, until I get something from your treating physician, you can't use it. Even though you have your card, I have the discretion to require confirmation that it is for purposes, for medical purposes. And that's the course of treatment that your doctor is recommending because you're under the court supervision. Okay.
Understood, Judge.
All right. So when's the last time you used the marijuana, sir?
Say a day or two ago.
All right, so you're not currently under the influence? Okay. And just so you know, sir, as well, when you obtain the communication from your treating physician, it's important just for your treating physician to indicate how long you've been a patient there. Okay? Because then we know whether or not, how much of your medical history they know and how often you go back and things like that, okay? So I'm going to order bonding conditions are continued. You're to go over to probation. You're going to get all your next steps, okay?
Do we know a sentencing date yet or no?
They will give you the sentencing date and you can coordinate that with your schedule, counsel.
All right, very good. Should I do that with them now? Or go- Okay, very good.
Have a good day.
But
Thank
nice
you.
to see you again.
You as well. All right, let's go on the record in the matter of the City of Riverview versus Thomas Drisga, 26259A. And the,
Morning, Your Honor.
good morning.
Dan Cameron, on behalf of Thomas Griffith, Your Honor, who stands to my right, Your Honor. For purpose of arraignment, Your Honor, the defendant will waive a reading of the charges and stand here.
All right, good morning, and good morning, sir. Your name for the record, please.
Thomas Drisga.
Okay, and thank you for dressing appropriately for court. And counsel, did you already indicate what you wanted to do for the arraignment? Or no? Did you already indicate what you wanted to do for the arraignment or no?
Defendant would waive a reading and stand.
Okay. The court will waive the formal reading after plea of not guilty for purposes of the arraignment. And then counsel as to the pretrial.
I have had an opportunity to speak with the Riverview prosecutor. The two original charges will be dismissed. Mr. Driscoll will enter a responsible plea to double parking. He understands his rights, did execute an advice of rights, and is prepared to establish a factual basis.
Okay. Sir, please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this matter be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay. And sir, you heard the plea that was placed on the record, correct?
Yes, Your Honor.
As to the amended charge of double parking, how do you plead? Responsible or not responsible?
Responsible, Your Honor.
And you've gone over your advice of rights with your attorney, correct?
Yes, Your Honor.
And you understand that by entering into a plea, you'll be waiving some of those rights.
Yes, Your Honor.
You also understand, sir, the possible penalty as a result of your plea, whether in this court, any other court, or administrative agency.
Yes, Your Honor.
Knowing all of that, do you want to continue with your plea?
Yes, Your Honor.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No, Your Honor.
Any immigration issues?
No.
All right, the court will accept your plea as knowing and voluntary and dismiss the original two charges for the plea agreement. And sir, I read in the police report that you saw the vehicle and you didn't know what to do. You're 22?
Yes, Your Honor.
Okay. When did you take driver's training?
When I was 15.
Okay. So it's not that long ago.
No, Your Honor.
Didn't you learn what to do when you were in driver's training?
Yes, Your Honor.
So what do you do?
I should have not went through, Your Honor.
Right, so what should you have done?
I
Tell me what you
should,
should not have done. What should you have done?
I should have pulled over to the side and went a different way.
Yes. Yes.
I think he was just confused. He was the second car, followed the car in front of him. It was just a lapse in judgment.
All right, sir, it's $200. Do you have that to pay today?
He will pay it by Friday if that's okay with the court.
Do you work, does he work?
He doesn't work and he's also a student and he also pays rent. He lives outside of his parents' home, so.
Okay, the court will have you pay this by Friday, April 17th.
Thank you, French.
Have a good day. Thank you. Okay. We have a record in the matter of the city of Wyandotte versus Brandon Spearman, 26234.
Your Honor, good morning. Good morning. Durant, B33828. Appearing on behalf with my client, here's my right. This is the date and time set for previous arraignment pre-trial. Sir, please state your name loudly for the record.
Brandon Spearman.
All right, thank you also for dressing appropriately for court. At least it seems as though you're appropriate for court. I can't really see over the bench here, but all right, counsel, as to the arraignment.
As for arraignment, Your Honor, waive for reading stand view. And will advise all the rights and stand and the charges and all maximum penalties. And we would ask for a plea of not guilty will be entered on this behalf.
The court will waive the formal reading, enter plea of not guilty for purposes of the arraignment. And counsel, as to the pretrial.
Pre-trial, Your Honor, my client is that he would like a few weeks to clear up some other matters that he has pending. He has some unpaid tickets. He wants to get those taken care of. Probably he will be able to do that. We originally asked for 2 weeks, but I noticed that I was not here in 2 weeks. So the earliest time here is May 4th, I believe it is.
All right, we will adjourn this to May 4th at
9:45.
9:45 a.m. Sir, where do you have matters to clear?
Alan Bar, Your Honor.
How many matters do you have to clear? Do you know?
I believe one, Your Honor.
Okay, and that's something that you can do in the next in the next 2 weeks?
Yes, Your Honor.
Okay. And how did you get here today, sir?
I was dropped off by my wife, Your Honor.
He does have a key in his pocket, Your Honor, but it's not to a motor vehicle. Is that correct, sir?
No, it is to a motor vehicle, but it was actually because my wife and I just this weekend, and the keys to the house were on the key ring, and I had to give that to her. And I took my keys with me this morning, left her keys. So I had one key, some keys, or the spare one. But
Sounds interesting.
no,
You have a single car key and not house keys.
right, because she needed the house keys to get back. And
Do you need the car key to get back to the house?
no, she had her own set of car keys, but I had the one key to the house because we just moved in this Friday, like this Saturday. So we only had one key and it was on my key ring.
And so it's a key to what car?
It's a key to our car.
I don't know what car that is.
That Acadia, I'm sorry, I wouldn't,
That's okay. What color is it?
it's a dark gray Acadia.
And so it's not out in the parking lot.
No, you're.
We had this
You'd
conversation.
be surprised, sir, how many, you seem amused that I'm asking these questions. You'd be surprised how many people actually tell me they didn't drive and yet their car is out in the parking lot.
No, I'm not surprised, Your Honor, just because we did have this conversation.
Okay. All right. All right, so the court's going, have you ever failed to appear in court for any reason, sir?
No, Your Honor.
Are you on probation or parole anywhere?
No, Your Honor.
All
In
right.
addition, Your Honor, he works full-time as a sales manager for Streamline Data. And he also does DoorDash on the side when he has a valid license.
Well, he better.
When he has a valid.
Uh-huh. Okay.
Right, sir? Right. All right.
Okay. So, sir, get that matter taken care of and, don't drive if you want to get your license back.
Yes, Your Honor. Thank you.
The court will order a $5,000 personal bond you not to operate a motor vehicle without a valid license. Just have a seat. You get a copy of your bond conditions, okay?
Thank you.
Have a good day.
Good.
We're on the record in the matter of the City of Wyandotte or Riverview versus Chloe Snyder, 26233. Can you grab Neil, please? Thank you. Well, we're doing your next one right after Mr. Du Bois. So if you can just hold on for just a couple moments.
Sure, ready.
Good morning.
Good morning, Your Honor. Ms. State name, please.
Chloe Snyder.
Your Honor, Neil.
I'm not sure if we picked you up.
No. Chloe Snyder.
Okay, thank you.
Your Honor, Neil LeBlanc, we have Chloe Snyder.
All right, thank you and good morning. And ma'am, thank you for dressing appropriately for court. Today is the date scheduled for the arraignment pretrial in this matter and counsel as to the arraignment.
My client waives formal reading and stands before the charge.
The court will waive the formal reading, enter a plea of not guilty for purpose of the arraignment as the pretrial counsel.
As to the pretrial, reviewed the allegations against Ms. Snyder with her. And she given me a lot of the background here at this point. The prosecutor and Ms. Snyder would be the best resolution of it. It was via plea under 771.1. She's able to provide us with detail about how situation is and probably proof of that, so to speak. So that's the basis of the plea.
Please raise your right hand. You solemnly swear or affirm testimony about to give in this matter be the truth, the whole truth, and nothing but the truth. Okay. Ma'am, you heard the plea that was placed on the record, correct? As to the charge of compulsory school attendance, parental neglect, how do you plead?
Okay.
And you have gone over your advice of rights with your attorney, correct?
Yes.
You also understand the possible that by entering into a plea, you'll be waiving some of those rights.
Terryana.
Are you picking her up?
Yeah.
Okay, make sure you keep the volume up, okay, please. You also understand the possible penalty as a result of your plea, whether in this court, any other court or administrative agency.
Yes.
Knowing all of that, do you want to continue with your plea?
Terryana.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
Has anybody? You understand what the 771 status is, correct?
Yes.
All right. Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
Any immigration issues?
No.
Counsel, do you compose your client?
Yes, and well, Ms. Snyder, you have in the file, she's age 9 at this point, a student in the Riverview Public School System. And past year, there have been issues. The school administration has consulted with you regarding number of absences and a number of charges. Is that correct?
Yes.
You admit you have not been able to make sure that she gets to school as she's supposed to. You understand that Michigan is required, her parent, you're obligated to get her to school, correct?
Yes.
And you admit that at least some of the reports regarding excessive absences and tardies, that is true.
Yes.
Right?
The court is satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea as charged and will determine the sentencing and your eligibility. 1.1 status at sentencing. And Counsel Esteban.
Esteban, listen, you know, criminal. She's, she's a hardworking mother. She has 3 kids. She gets split custody with, another school district. She has a daughter with ADHD. She's a woman that's been pulled in a lot of directions. Her daughter is getting the necessary medical care. She explained there's insurance issues and so forth, that she's been on a correct path. She understands her obligations here. She's not a criminal. And so I don't think there's any issue that she's not going to appear. We'd ask for personal bond.
Okay, so ma'am, since you've received this citation or notice to appear, how has the attendance been?
But yeah, new medication and everything's been good.
Okay. So your how long has she been on the new medication? All right. And how are her grades?
Good, she's passing.
And ma'am, I can understand that it can be overwhelming having multiple school districts to have to mesh well as best you can. How old are those children?
6 and 7.
Okay. Okay, the court's going to, and you're not on bond in any other jurisdiction, is that correct? Court's going to order a $5,000 personal bond. Your daughter is not to miss any further school without a doctor's note. Probation, you'll get all of your next steps as well as a copy of your bond conditions. Thank you. We are on the record in the matter of the city of.
All right, and move on here in just a second. But a couple of you were complaining about issues like getting kicked off the stream and everything leaving the studio this morning is leaving healthy. But I just did pull up a down detector for YouTube, and there has been complaints over the last 12 hours or so of some intermittent issues like this. So it appears to be on their end. The best thing you can do if you have issues is just refresh. Let's go to Texas Judge Stevens, but before I hit the go button, once again, he has the best facial expressions ever. This is just how I paused it. He is such an animated dude. But let's see what's going on with him.
26 CR 49, the state of Texas versus Eric Scott Hall. You were Mr. Hall?
Yes, sir.
Present?
Yes, sir.
With your attorney, Mr. Dusler, and the state's attorney present. Does the defendant waive a formal reading of, the indictment and the arraignment here? Can we proceed in summary? And I was mentioning this. You're charged with theft, and I'm looking at 12 prior theft convictions in paragraph 2. Then there's a state jail felony of forgery, another state jail felony of forgery, another state jail felony of illegal possession of a controlled substance. So, that makes 15 prior convictions of crimes that are either felonies or serious thefts. What do you think? It's about time you changed your way.
Yes, sir. Since this crime, I've completed the drug rehabilitation behavior modification class, and I'm taking all steps.
What did how's that working for you?
It's, I haven't been released yet, but I'm going to
Well,
practice.
what did it do to change your decision
It
making?
changed my mindset, and gave me tools to work with, that's to talk to somebody, go get a job, be productive in life.
Oh, you're
And just think better,
You're 50
make better decisions.
What are you, 55?
Yes, sir.
Well, it's never too late to start thinking about getting a job at your age, but responsibilities are important. Do you have a family?
Yes, I have a fiance. My mom and dad passed away. I do have a
Do
fiance.
you have any children?
Yes, sir. Her children. Yes, sir.
Her children?
Yes, sir.
Well, you're supposed to,
Yes, sir. I deeply.
when you
regret-
have children,
I deeply
and-
regret all bad decisions I've made, Your Honor.
like, it's never too late to start making the right choice.
Thank you, sir. Yes, sir.
What are we gonna do now?
We have an agreement, 2 years TDC.
What does he need to plead to?
He needs to plead to counts 1, 2, and I think that'll take care of it, 1 and 2. So.
No, that just makes a state jail felon.
He's got to plead to it all, Judge. Okay, that's fine. To enhance it to state jail felony punishment. Or to third
All right,
degree,
hold
excuse me.
on. So
Third degree.
one,
plus
two,
enhancements, and then the 2
and
priors.
then the 2 priors, are they to be, paragraphs 3 and 4 are convictions on the same date, and then 4 is a conviction on another date. Does it, so something is excluded here, right?
No, sir.
Well, so is it 1, 2, 3, 4?
Yes, sir.
That's what works.
That's
And then
what-
5,
Yes, sir.
we'll just leave off. All right, anyways, formal reading, we can go in summary. In summary, Mr. Hall, paragraph 1 of this extensive criminal indictment showing an extensive criminal history of yours states that on or about November 25th, 2025 in Jefferson County, Texas, you committed the state jail felony of theft. And actually, paragraph 1 states you committed theft in a value of less than $2,500. But paragraph 2 goes on to allege you have 12 prior theft convictions out of county courts at law and criminal courts and district courts of Jefferson County, Texas, Montgomery County, Texas, Orange County, Texas. Paragraphs 1 and 2 constitute a state jail felony. Do you understand, sir?
Yes, sir. Your Honor.
However, we're not through. Paragraphs 3 and 4 go on to allege that on January 8th, 1999, in this criminal district court of Jefferson County, Texas, you were convicted of the state jail felony of forgery in each of 2 cases. So that means that paragraphs 1 and 2, which constitute a state jail felony, 3 and 4, if proven true, means you are punished as though you were it's a third degree felony.
Yes, sir.
Right? Is that right, everybody?
Yes.
Yes, sir.
And that means you are facing no less than 2 nor more than 10 years confinement in prison, and a fine up to $10,000 can be assessed as well. Not too often do we have prolific theft record like this. So this is a third degree felony, again, no less than 2 nor more than 10 years confinement in prison, and a fine up to $10,000. And an agreement has been reached and all of that, but you would be pleading guilty, sentenced to 2 years in prison, which seems awfully low for your rich criminal history. But it's another felony conviction, which then makes you, I think,
It being a theft, it won't impact any of his history, Judge.
He's got these several prior convictions out of this court for thefts. So those have to be felonies. Are all those state jails?
Yeah, the most, at this rate, with the amount that he's stealing, he's going to be stuck at state jail felony.
He's got a third-degree felony now.
He does, because there are 2 forgery convictions from the 90s.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir, Your Honor.
How do you plead again to a paragraph 1 of this indictment, alleging you committed the offense of theft on or about November 25th, 2025?
Guilty, Your Honor.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir, Your Honor.
And paragraph 2, which alleges these 12 theft convictions, are those all true and correct as they are alleged?
Yes, sir, Your Honor.
And are you pleading true and correct of those voluntarily and because those allegations of theft convictions are indeed true and correct?
Yes, sir, Your Honor.
And finally, paragraphs 3 and 4, the state jail felonies of forgery in 1999 in this criminal district court of Jefferson County, Texas. Are those 2 forgery convictions, state jail convictions, true and correct as they are alleged? And are you pleading true and correct of all of those voluntarily and because they are indeed true?
Yes, sir, Your Honor.
Show you what's marked here as states. Exhibit 1, did you sign that document voluntarily, understand it, discuss it with your attorney, or the contents all true and correct?
Yes, sir, Your Honor.
States Exhibit 1 tendered into evidence without objection.
No objection.
It's admitted. Among other things, this states that you are indeed mentally competent to enter your guilty plea. It is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your attorney. All of this is true. It states, so help you God.
Yes, sir, Your Honor.
States Exhibit 1 is made a part of the record for all purposes. Pre-sentence report waived here?
Yes, sir.
Yes, Your Honor.
Stand by. I think technically here, it's a state jail felony, punished as though it were a third-degree felony.
That's correct.
That's accurate, Judge.
All right, I'm going to find here, Mr. Hall, you have pleaded guilty in paragraphs 1, 2, 3, and 4, voluntarily, knowingly, intelligently. That is enough to States Exhibit 1 has been admitted supporting your guilty plea to find you guilty beyond a reasonable doubt. And that is enough to find you guilty beyond a reasonable doubt of these 4 paragraphs. Paragraphs 1 and 2 constitute a state jail felony. 1, because you committed theft, even though it was less than a state jail felony in punishment, because you have 12 prior theft convictions in paragraph 2. Paragraphs 1 and 2 then constitute a state jail felony. Paragraphs 3 and 4, the prior convictions of state jail felonies in 1999, then bump the punishment of this state jail felony up as though it were a third-degree felony, up to 10 years in prison, no less than 2. So I hereby find you guilty of this state jail felony, punished though, as though it were a third-degree felony. I'm following this agreement. You are hereby sentenced to confinement in the state jail. In the institutional division of the Texas Department of Criminal Justice to serve a term of 2 years. Now, on this,
Probation. Okay. No, please, he's on probation. That says 2 years.
was this loss, it looks like it's body wash in the amount of $186.29. Was that returned?
I don't think so.
All right. Well, yeah, I know it may not, Mr. Ham, I'm working on this restitution part here. I know it may not practically matter because people who are destitute, like Mr. Hall, seems to be seem unable to pay restitution, but nonetheless, the law does provide that restitution can be ordered if it is lost and in the act of the theft. And here, $186 and 29 cents where the body wash was taken from the defendant. He has not paid for it. I'm going to order in the judgment that restitution be ordered in the amount of $186.29 to the complainant as representative and or owner of CVS Pharmacy as alleged in this indictment. It might not be paid, but it's just not fair not to order it. At least we're going to symbolize it that you're responsible for that. You have been a prolific thief now for your whole life. You don't even pay things back when you steal. You move on, steal again. And this will at least memorialize that you stole again. There's an amount, and the right, decent thing and legal thing would be to pay it back somehow.
Yes.
But I have a feeling that won't be done because I don't see anything in your history here that shows that you do pay things back. But it's going to be ordered nonetheless. And all I can do is say, do the right thing.
Yes, sir.
But you haven't done the right thing. For over 27 years.
It's time to start, Your Honor.
Don't just talk about it.
Yes, sir.
Walk the walk
Yes,
of
sir.
responsibility.
Yes,
Just
sir.
don't talk. You make promises, but you've got all those convictions.
Hold this one for you, Your Honor. I'm going to change.
Don't just talk.
Yes, sir.
Do it.
Yes, sir.
That's the test
Yes, sir.
for character. And when you do it, let me know so I can say, good for you. And
Thank you, Your
then
Honor. Yes, sir.
I'm kind of not going to hold my breath. Make me believe it
Yes, sir.
by what you do. Anything
sir.
else? That is all. Okay.
Thank you, Your Honor.
Okie dokie, friends. Good morning once again. My name is Dan. It is good to have you here with me this morning. Let's go back
Right.
to...
Don, who is-
Hush, Judge. I'm talking. Let's go back to Michigan. Judge Oakley. If you want to have fun, by the way, think of the Macarena song, but put Oakley in it instead. And then you're like, hey, Oakley. It's good times. So give that a try. Anyways, here we go.
This is docket 24693 FC, People of the State of Michigan versus Deontay Antoine Chapman. Counsel, your appearance for the record, hands out of your pockets. Sir, hat, did you have a hat on?
No.
Counsel?
Good morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Good morning, Your Honor. Jacob Sarge IV, Assistant Public Defender here on behalf of Mr. Chapman.
Please
Mr.
raise
Chapman.
your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, ma'am.
You may put your hand down. Have you consumed any alcohol, marijuana, any medications whatsoever yesterday or today?
No, ma'am.
Any sign of fever, COVID, or other illness?
No, ma'am.
Is there any medication you're supposed to be on that you're not on?
No, ma'am.
Have you had an opportunity to speak with your attorney?
Yes, ma'am.
We were scheduled for a jury trial. I understand a plea offer was made and you are waiving your right to a jury trial. Is that correct?
Yes, ma'am.
And you made this decision freely, voluntarily. It's your own decision after you talked with your attorney and looked at all the circumstances?
Yes, ma'am.
All right. On behalf of the people, for the record, what is the plea offer at this time?
The plea offer is for the defendant to plead no contest to count 2, home invasion of first degree, count 4, assault by strangulation, count 6, interfering with a crime report, and count 7, domestic violence, second offense notice. There is a fixed minimum sentencing agreement here for 36 months in MDOC. I will note for the record that is a below guidelines sentence, and that is, the people are aware of that, the defense is aware of that, that is intentional. This plea was discussed pretty good length. The victim is on board with it, as she would much rather see Mr. Chapman be a productive member of society than spending a large chunk of his life.
It counts 1, kidnapping, 3, unlawful imprisonment, 5, assault by strangulation, and 8, domestic violence. Second offense would be dismissed.
Yes, Your Honor.
Any restitution?
Not that I'm aware of, Your Honor.
And no contest based on civil liability, is that the reason?
That's correct, Your Honor. I would note that Mr. Chapman should be eligible for MDOC boot camp. Defense counsel is going to be requesting that Your Honor not oppose efforts for Mr. Chapman to get into boot camp after his sentencing hearing and at his sentencing hearing. Respectfully, consideration for potential entry into boot camp is a key consideration why Mr. Chapman has accepted this offer. Thanks.
There's no, I've not made any agreement or will I make any decision in regard to boot camp at this time.
Understood, Your Honor.
You understand all of that, sir?
Yes, ma'am.
Full, fair, accurate, and complete?
Yes, ma'am.
Counsel, are you waiving reading counts 1, 3, 5, and 8?
Yes, Your Honor.
And sir, you still live on Chevrolet Drive?
So, no, ma'am.
Let me see if you put the new address on the, so you live on Court Street?
Yes, ma'am.
And who do you live with?
My mom.
Did you graduate high school?
Hmm?
Did you graduate high school?
Yes, ma'am.
Are you employed?
Yes, ma'am.
What do you do?
I'm working at Family Dollar right now.
Yeah, what?
Family Dollars.
Are you a US citizen?
Yes, ma'am.
At the time you committed these offenses that you're going to be pleading to, were you on probation, parole, or bond conditions before this court or any other court? On a different file?
I don't think so.
Well, you know. Were you supposed to appear in front of any other judge?
No, ma'am.
Okay. As to the reading of the felony information, counts 2, 4, 6, and 7.
Yes, Your Honor. In the name of the people of the state of Michigan, the prosecuting attorney for this county appears before the court and informs the court that on or about December 23rd, 2022 through January 14th, 2023 at 1419 Rio Avenue, City of Lansing, Ingham County. The defendant on or about January 14th, 2023, count 2, home invasion of first degree, break and enter, or to enter without permission, a dwelling located at 1419 Rio Avenue, Lansing, Michigan, 48910. And while entering, president, or exiting, did commit assault, or while entering, president, or exiting the dwelling, Aubriana Richardson was lawfully present there, contrary to MCL 750.110A2. This is a felony, the maximum penalty of up to 20 years and or $5,000. Consecutive sentence may be imposed for any other conviction arising out of the same transaction. And because I can't remember if I said it during the plea, it is concurrent sentencing as part of the agreement.
Let me make sure that's on the Yes, you put it on the plea sheet, minimum 36 months concurrent.
Perfect, thank you.
Thanks.
Then for count 4, assault with intent to do great bodily harm, that's the murder or by strangulation. On or about December 23rd, 2022, the defendant did make an assault on Adriana Richardson by strangulation or suffocation, contrary to MCL 750.84. This is a felony with a maximum penalty of up to 10 years and or $5,000. DNA is to be taken upon arrest. A consecutive sentence may be imposed under MCL 750.506A if the assault was committed in a place of confinement. Then for count 6, interfering with a crime report, committing a crime / threatening to kill or injure. On or about December 23rd, 2022, defendant did retaliate, attempt to retaliate, or threaten to retaliate against another person for having reported or attempted to report a crime committed or attempted by another person by threatening to kill or injure a person, contrary to MCL 750.483A2B. This is a felony with a maximum penalty of up to 10 years and or $20,000. Consecutive sentence may be imposed for any other conviction. And finally, for count 7, on or about 12/23/2022 for domestic violence, the defendant did make an assault or an assault and battery upon Adriana Richardson, an individual with whom he had a child in common, or a resident or former resident of his household, or an individual with whom he had a dating relationship, contrary to MCL 750.812. There could be restitution if this offense resulted in damage to another individual's property, or physical injury or death to another individual for MCL 780.811A. This is normally a misdemeanor with a maximum penalty of up to 93 days and or $500. A consecutive sentence may be imposed under MCL 750.506A if the assault was committed in a place of confinement. But under the second offense notice, take notice that the defendant was previously convicted of assaulting or assaulting and battering his or her spouse, former spouse, an individual with whom he or she had a dating relationship, the individual with whom he or she had a child in common, or a resident or former resident of his or her household, or of knowingly assaulting a pregnant individual by violating MCL 750.812 on or about December 11, 2018, and therefore, upon conviction, will be subject to an enhanced sentence under MCL 750.814. The restitution provisions are the same, but the misdemeanor is now 1 year and or $1,000. A consecutive sentence may be imposed under MCL 750.506A if the assault was committed in a place of confinement. Court shall order law enforcement to collect the DNA identification profiling sample before sentencing or disposition, if not taken at arrest, and this was against the peace and dignity of the state of Michigan.
Sir, did you understand what was just read?
Yes, ma'am.
You understand count 2, home invasion, first degree is a felony punishable by 20 years and or $5,000?
Yes, ma'am.
And you understand count 4, assault with intent to do great bodily harm less than murder by strangulation is a felony punishable by 10 years or $5,000?
Yes, ma'am.
Count 6, interfering with crime report, committing crime, threatening to kill or injure is a felony punishable by 10 years and or $20,000?
Yes, ma'am.
And domestic violence, normally a 93-day, because it's a second offense notice, is enhanced to 1 year. You understand all of that?
Yes, ma'am.
Sir, it looks like you signed the advice of rights form. Did you read it before you signed it?
Yes, ma'am.
Did you understand what you read?
Yes, ma'am.
And if you had any questions about your rights, were you able to ask those of your attorney?
Yes, ma'am.
Now, sir, is your DNA on file, or did they swab you at the time of arrest?
I think it's on file. I believe it's on file.
All right. And do you understand that by pleading, you are giving up your automatic right of appeal if you had that jury trial that we were scheduled for, if you didn't like the outcome? Court of Appeals must take a look at your unhappiness, but now by choosing to plead, it becomes their decision if you are allowed to plead. I'm sorry, if you're allowed to appeal.
Yes, ma'am.
Sir, as to count 2, home invasion, first degree, how do you plead?
No contest.
And that's based on civil liability?
That's correct, Your Honor.
You agree with that, sir?
Yes, ma'am.
And as to count 4, assault with intent to do great bodily harm less than murder or by strangulation, how do you plead?
No contest.
As to count 6, interfering with crime report, committing crime, threatening to kill or injure, how do you plead?
No contest.
As to count 7, domestic violence second offense, how do you plead?
No contest.
You understand that you are giving up your right to a jury trial and holding the people to their burden of proving beyond a reasonable doubt, and on any count, they could not prove guilt by guilty by reasonable doubt. I'm sorry. I haven't had my coffee yet. On any count, they could not prove your guilt beyond a reasonable doubt, then that count would have to be dismissed. Do you understand that?
Yes, ma'am.
And you'll not be able to cross-examine any witnesses and nor will you be able to provide a defense. Do you understand that?
Yes, ma'am.
Sorry. And sir, you decided to enter into this plea finally after all this time, after talking with your attorney, and no one forced, threatened, or coerced you.
No, ma'am.
And no one promised you anything other than this plea agreement, correct?
Yes, ma'am.
And you decided to plead after you talked with your attorney, and you've been happy with his representation throughout these matters. Is that all correct?
Yes, ma'am.
Thank you. By stipulation of counsel, the Lansing Police Department case report 235-1900594. The report date is January 18th, 2023, and it indicates that law enforcement was dispatched on that date and made contact with the victim, who stated she was assaulted on December 23rd, 2022, and on January 14th, 2023. The victim had bruises on her face and body from the assault that occurred on January 14th, 2023. This occurred at the specific location known as 1419 Rio Avenue in the city of Lansing County, Bingham, state of Michigan. On December 23rd, 2022, the victim stated that around 1900 hours, she allowed Deontay to come into the residence and Terryana, the victim, left the house and came back shortly after. When she came inside, Deontay stated to her, "Your feelings don't matter. I'm only here for the baby." He went to the bathroom. As she was coming out, Deontay then physically assaulted her. He began pushing her back into the bathroom. She went upstairs into her bedroom where the assault continued. He began punching her in the face and body. Then he began physically strangling her with both hands. His phone in hand with his aunt on the phone. The victim was screaming for help, but the aunt on the phone did not call 911 for officers to respond. On January 14th, 2023, Deontay called the victim to see if the children needed personal items. She and her cousin and another male were over. Deontay could hear the male's voice on the phone, so he showed up to her residence unannounced. The victim saw Deontay front door. He forced his way into the residence and began questioning her cousin and the male as to why they were there. Deontay then grabbed the victim by her arm and dragged her into the bedroom. into the bathroom. Deontay began strangulating the victim again while in the bathroom with both hands. She said he strangled her approximately a minute while being strangled with both hands on her neck. She said it was hard for her to breathe. He let her go and began physically groping her butt and body. She stated he tells her every time they make contact that he does not care and he will kill her. And she is in fear of her life and children's lives. There was a previous domestic on June 28th. Must be 2022. It says 222.
Yeah.
20.
Council stipulated.
Yes, Mr. Zero.
Yes, Your Honor.
Thank you.
Thank you.
That he was taken in custody for. There is a bond conditional in place until June 28th, 2023. She stated he will call her with different numbers or have his family members check in on her. Deontay has made fake social media accounts to contact her. The victim stated Deontay will make threats of killing her when they are on the phone or in person. I think we have the home invasion and the assault with intent to create bodily harm unless the murder by strangulation. The interfering with crime report.
If I can approach here, I think there's one sentence that was highlighted that can solve this pretty quickly.
What you may approach, but is it on the part that I have or?
Victim statement, second paragraph down, there's a sentence that reads, Deontay stated to her, he would kill her and flee if she gets involved or calls the police.
All right, stipulate to that, counsel?
Yes, Your Honor.
And then if the defense will stipulate to the prior conviction of misdemeanor domestic violence on December 11th, 2018.
Yes, Your Honor.
I believe that is the last piece. That should be a sufficient factual basis, Your Honor.
Yes, Your Honor. Thank you.
Sir, as to the 36 months, do you understand that if I violate that, I would allow you to withdraw the plea and this matter would again go to the pretrial stage?
Yes, ma'am.
However, if you violate the law or bond conditions between now and sentencing, I don't have to honor that. And I don't have to allow you to withdraw your plea. Do you understand that?
Yes, ma'am.
Are counsel aware of promises, threats, or inducements other than those already placed on the record?
The people are not, Your Honor.
None, Your Honor. Thank you.
Is court complied with the court rule?
It has, Your Honor.
Court has, Your Honor.
I find defendant's plea has been freely, voluntarily, knowingly, and understandingly made without undue influence, threats, coercion, or promises of leniency. I also find the no contest plea to be appropriate based on civil liability. And there are sufficient grounds based on counsel's stipulations, as well as the information that I read from the police report. I think comprehensively all that put together for all four counts does make the factual basis. Therefore, counts 2, 4, 6, and 7 will enter. Counts 1, 3, 5, and 8 are hereby dismissed, along with any outstanding warrants, if any, related to this file. We have sentencing date?
June 24th at 11 a.m.
Does that meet with your schedule, counsel?
Yes, Your Honor. Thank you.
It should, Your Honor.
Is the intent that he be remanded today or June 24th?
It is not the intent, and I believe just to comply with MCL 770.9A, the court has to make the determination on the record that by clear and convincing evidence, he's not likely to pose a danger to other persons. On behalf of the people, I leave it to the court here, Your Honor. I know that there have not been violations with this victim, this case going on. I talked with her and she says that he has abided by no contact order for several years. It's been going on.
Does that include what probably should have brought to my attention or family court attention with the PPO, or he's contacted her through third parties.
I'm saying she told me, while this case has been going on, he has not violated the no contact order. He hasn't used third parties to violate the no contact order.
Okay, so what she reported in the police report did not pertain to this.
Correct.
Correct. Yeah.
Once this has been filed, once the case has been going, so I can't say that about many of my defendants.
Thank you, Your Honor. Respectfully, I would request that Mr. Chapman be allowed to stay out until his sentencing date. At this point, he has a very good record of compliance with Your Honor's orders. He has a job. He lives in another city, lives in Flint, Your Honor. He's on GPS tether monitoring. He has a stable place to stay. So he's been in compliance. He'll follow through and he'll get his pre-sentence interview done and scheduled. And Your Honor, respectfully, because of his excellent record so far of compliance, I request that he be allowed to stay out until sentencing. Thank you.
Sir, I will allow you to remain out.
Yes, ma'am.
But if there's any contact whatsoever, you violate the law, you do something against bond conditions, you'll be in lockup faster than you can blink. Got it?
Yes, ma'am.
Today, I'm going to ask you to go downstairs and make your appointment with probation. We have to have a pre-sentence investigation report done for sentencing. At the time of sentencing, you will be remanded to the Michigan Department of Corrections, so be ready and dressed for that. Do you understand?
Yes, ma'am.
Understand also, if you contact her or violate the law, I don't have to follow this agreement. So it's very important that you remain as you have been, not contacting her and abiding by all bond conditions. Do you understand that as well?
Yes, ma'am.
Anything further?
No, Your Honor.
Counsel?
Nothing further from the defense, Your Honor. Thank you.
Thank you. It's all for the record.
Thank you, Your Honor.
Did you have a question?
Yes, ma'am. You
Go
said,
back on the record. Yep.
I'm sorry about that. You said go downstairs and.
Your attorney's gonna direct you. It's
Okay.
easier than making a phone call. Otherwise, I have you make a phone call, make an appointment with probation within 24 hours. Sometimes it's tough to reach them. You're in the building. Before you go back to Flint, it just takes 5 minutes to make the appointment.
Yes, ma'am.
Do that. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Alrighty, friends, TCF Live. Looks like about 2 more hours to go. Hope you're all having fun. I know I am. Let's go to Miami-Dade, see how Mindy Glazer's holding up this morning.
Counts of grand theft, a second-degree felony.
2 cargos de hurto mayor, segundo grado, delito mayor.
3 counts of obtaining a vehicle by trick.
Y 3 cargos de obtener un vehículo a través de tranza o trampa.
A 1 count of unlawful possession of a stolen credit or debit card.
Un cargo de tenencia ilegal de una tarjeta de crédito o débito robada.
Possession of a stolen or fictitious driver's license.
Y tenencia de una licencia falsa o robada.
Possession of cocaine.
Tenencia de cocaína.
3 counts of a false statement.
De crédito a través de declaraciones falsas.
Disposing of personal property that is under a lien.
Deshacerse de propiedad personal que está bajo un embargue.
And resisting an officer without violence.
Y resistir a la autoridad sin violencia.
I will appoint the public defender's office for you.
Voy a nombrar a los abogados de oficio que lo representen.
So it's alleged here he went to Bowman Chevrolet and purchased 3 vehicles by fraudulent means with a counterfeit driver's license.
Alegan aquí que fue al Chevrolet Bowman y compró un vehículo, 3 vehículos a través de uso fraudulento.
He purchased a Chevy Suburban valued at $79,719.36.
Compró un Chevy Suburban 27 de marzo con el valor de $79,719.37.
He also purchased a 2025 Chevy Tahoe for over $123,000.
También compró un Chevy Tahoe del 2025 por más de $123,000.
He got financing for both vehicles.
Obtuvo financiamiento para ambos vehículos.
Actually, that was somebody who made that purchase was somebody named Alexander Quinoa. And then somebody goes and purchases a car a few weeks later named Robert Bruno.
La persona que hizo esa compra, de hecho, es Alexander Quinoa y después, o semanas después, hace la compra Robert Bruno.
Bruno's buying a BMW vehicle over $119,000.
Y Bruno está comprando un vehículo BMW con un valor de más de 119,000.
So Judge, just may clarify it. So he,
The male with them.
no, he pretended to be Quinoa. He portrayed himself as Quinoa.
Pues esto le podía aclarar, dice la fiscal. Él se hizo pasar por Quinoa.
So the licenses to purchase these vehicles were all fraudulent.
Las licencias de conducir que se utilizaron para comprar todos esos vehículos, todas fraudulentas.
They made contact with the real Mr. Alexander Quinoa, who's a white male, who said there were fraudulent purchases under his name.
Se comunicaron con el verdadero señor que dijo que era un hombre blanco él, y él dijo que utilizaron su nombre para hacer las compras.
And he didn't give authorization to the unknown black male that portrayed him to purchase two vehicles.
Él era un hombre blanco y él dice que no le dio autorización al hombre negro para que comprara esos vehículos.
Sir, you are ordered to stay away from Bowman Chevrolet at 11855 Southwest 152nd Street in Miami, Florida.
Muy bien, señor, se le ordena que se mantenga alejado del Bowman Chevrolet en el 11855 Southwest 152 calle en Miami, Florida.
Miss Seth, do you know when he entered the country?
¿Saben cuándo entró al país?
Judge, I do have that he's got a prior federal conviction.
Sí tengo que tiene una condena anterior federal.
For what?
It was for, it looks like distribution of methamphetamine.
Parece que fue por distribuir metanfetamina.
From when?
That was from 2017, and it looks like he got off of supervised release in 22.
Eso fue del 2017 y parece que lo dieron de alta de la supervisión en el 2022.
Ms. Corey, anything you want to say regarding probable cause?
¿Algo que quiera decir la abogada de oficio sobre el motivo fundado?
No, Judge, not this time.
Ahora mismo no, juez.
There's probable cause for everything.
Hay motivo fundado para todos los cargos.
Count one, organized fraud, $15,000 bond.
Cargo número 1, fraude organizado, $15,000 de fianza.
Count 2 and 3, grand theft of first degree felony is $15,000 bond each count.
Cargo 2 y 3, hurto mayor primer grado, $15,000 por cada cargo.
Count 4, fraudulent use of identification. I'm not sure why that's charged as a first degree felony. It should be a third.
Cargo número 4, uso fraudulento de una identificación. No sé por qué debería de ser un delito mayor tercer grado, no primer
It'll
grado.
be $2,500.
$2,500 de fianza por ese cargo.
Count 5, grand theft, a second degree felony is $7,500.
Hurto mayor segundo grado, 7,500.
Count 6, 7, and 8, obtaining a vehicle by trick will be $2,500 each count.
Y cargos 6, 7 y 8, obtener un vehículo a través de una trampa, $2,500 por cada cargo.
Count 9, unlawful possession of a stolen credit or debit card, $2,500 bond.
Cargo número 9, tenencia ilegal de una tarjeta de crédito o débito robada, $2,500 de fianza.
Count 10, possession of a stolen or fictitious driver's license is $2,500.
Y el siguiente cargo, tenencia de una licencia de conducir falsa o robada, $2,500.
Count 11, possession of cocaine, $2,500 bond.
Tenencia de cocaína, cargo número 11, $2,500.
Count 12, 13, and 14, obtaining property by false statement will be $500 each count.
Cargo 12, 13 y 14, obtener propiedad a través de declaraciones falsas, $500 cada cargo.
Count 15, disposing of personal property. I'm not sure with the lien. Don't know if I saw that. Let me see.
A ver, el último cargo, deshacerse de propiedad que tiene un gravamen. Deje
No,
ver.
You want $1 on that one?
that's fine.
$1 por ese cargo está bien.
Is it with a Nebia judge?
Oh, yes. Count
But-
16, resisting an officer without violence is $500.
Cargo 16, resistir a la autoridad sin violencia, $500. La fiscal
That's
pide
plus
un requisito Nevia.
Plus a Nebia requirement, you have to show the money used to post your bond is from a legitimate source of funds.
Y es un requisito Nevia significa que tiene que demostrar que el dinero que va a usar para pagar su fianza viene de una fuente legítima.
Good day, sir.
Que tenga buen día, señor.
Can we recall the PCH? I've got an officer logged on, a detective.
Okay. Page 2, Yamela Lucas.
Detective, you have to accept the promotion to a panelist and then unmute and turn on your camera.
Yes.
Detective, raise your right hand, please. To be sworn. Do you swear or affirm the testimony you are going to give in this proceeding will be the truth? If so, state I do.
Yes, I do.
What's your name and what police department?
Detective Jacqueline Hoy, I'm with Homestead Police Department.
Thank you. Go ahead, state.
So, Detective, this was set for a hearing today. I'm not sure why. I think maybe
Because
the
she was
description
arrested
of what a
possession of a
switch.
short barrel rifle, shotgun, or machine gun. All it says here is that it had a switch attached. It didn't
So
describe what
can-
a switch is. Go ahead.
Can you please describe what a switch is?
Yes, a switch is supposed to make, it's an illegal part of a firearm that makes the semi-automatic pistol turn into a automatic pistol.
All right, I don't have any further questions.
Ms. Corey, any questions?
No, Judge, thank you.
Thank you for coming in.
Thanks, Detective.
Detective.
Thank you.
There's probable cause for the charge. It's a second degree felony, $7,500 bond. Good day. Next on page 9, Adrian Griffith. Good morning. So you were arrested for carrying a concealed firearm, tampering with physical evidence, and possession of improper exhibition of a weapon or firearm. I will appoint the public defender's office for you. It's from April 11th. Can you afford to hire lawyers?
Yes.
You have money to pay for your lawyer?
Not right now, though. To work.
What?
I have not right now, though, but I have to go to work. But
How much you make?
bi-weekly, 1,500.
That's every 2 weeks?
Yes. Yes.
Appoint the public defender's office for you.
So the reason why he's not allowed to carry a gun is because you previously applied for a permit and it was denied. because of a withhold and according to the AA form, because he's a registered gang member.
Okay, so there's probable cause for count one. Is he the one tampering with it or somebody else?
It says that he bent over, reached under the passenger seats, began to manipulate and remove the extended magazine, and then open the glove box to avoid the CCF arrest.
Okay, I'll find probable cause for count 1, 2, and 3. 3, I'll do an ROR. Well, I don't know, is it in proper exhibition?
I guess
I'll split it. Count 1, carrying a concealed firearm. Do you have an objection to a pretrial state?
yes, state's requesting a bond.
Judge, I would ask for pretrial. I'm not sure that being a supposed documented gang member is a basis not to be able to conceal a firearm.
But it does say he was denied the permit.
Well, but it depends on
Those-
when. So it means he could never, ever, because he was denied at some point.
Pretrial's fine. And pretrial alternate bond, count 1 is $2,500. They tell me he's eligible. Count 2, tampering with physical evidence is $2,500. Count 3, improper exhibition of the weapon is $500. Have a good day. Justin Cantillo, page 9. Good morning, sir. You were arrested for fleeing and eluding a police officer and possession with intent to sell THC oil. I will appoint the public defender's office for you.
No intent.
Just possession of a controlled substance. There's probable cause for fleeing and eluding. He's on a dirt bike doing wheelies and fleeing from the police when they're trying to pull him over. Count 1 is $2,500. Count 2. What do you want for that? ROR, $1? He's on
$1.
juvenile probation. I'll do ROR for count 2. Welcome to adult court. Now you're facing prison time if you're found guilty. You need to follow the law. It's no more slap on the wrist and a hug from juvenile court. There's serious consequences. You're going to lose your freedom. Next, Bobo Nature Cherries and Hannibal. Page 9. Good morning, sir. You were arrested for aggravated battery on a law enforcement officer and resisting an officer with violence. I will appoint the public defender's office for you. All right, so he's riding a bicycle and the police are trying to stop him at 3:12 in the morning. And he doesn't stop. He keeps asking why they're trying to stop him. So let's see. So he struck, let's see. They grabbed him off his bicycle. He resumes a fighting stance. So he struck the officer on the right side of his head near his temple. Why is it aggravated?
It's not, just battery on a law enforcement officer.
Okay. Count one, battery on a law enforcement officer is $5,000. Count two, resisting an officer with violence. I'll set it at $1,000. Good luck to you, sir.
Okie dokie. As Michael pointed out in the chat, she seems to be doing incredibly well today, so good for her. Let's go back up to Michigan, Huron County, see what's going on with Judge Prill.
Files 25, 7287 and 7288 FH, time and date set for sentencing. Defendant is present, represented by Attorney Dallas L. Rooney. People are represented by Prosecuting Attorney Timothy J. Rakowski. On February 11th of this year, the defendant entered no contest pleas in the first file, the fraudulent use of building contract fund. Count two, no contest and non-sufficient funds check, $500 or more. Ms. Karen Everlands prepared the pre-sentence report dated March 16, 2026. Also, letters have been submitted to the court, which the court has reviewed, and even letters as late as today from an Antoine LaPratt, Antoine LA, capital PRATT, and a letter from Cindy Langley. There were other letters submitted as well, which the court has reviewed. I don't have the names in front of me, but again, I did read them. Mr. Rooney, have you and your client had the opportunity to review the pre-sentence report?
We have.
Are there any additions, deletions, corrections, or objections other than that?
No to those and no to the guidelines.
Do you agree with that, Mr. Shears?
Yes, Your Honor.
Thank you. Mr. Rakowski, any objection to the report as well as guidelines?
No, Your Honor.
Thank you. Mr. Rooney, what would you like to say on behalf of your client before the court imposes sentence?
Well, Your Honor, my client's going to turn 40 next week, I believe. It's no prior felonies. They have a handful of misdemeanors, mostly driving or drinking related cases. He graduated Caseville High School. He had 1 year of college. He played semi-professional basketball in foreign countries for about a year. He's head coached basketball in various high schools and even leagues for children for the last 10 years. He has been a self-employed roofing contractor here in the county for about the last 5 years. You may have seen his billboards out and about in the county one time, in the past. At the peak of his business, he did almost $1 million a year. Unfortunately for him, though, the business grew faster and greater than his skills could properly manage, which was a contributing issue with these cases. Also, around the same time that these checks and failure to complete work cases happened, he had a trusted employee who literally, I heard this from building and zoning like a couple of years ago now, but he had an employee who was literally impersonating Mr. Shears and taking money from people for deposits for other roofing and siding jobs. And then eventually the people were getting roofing and siding, and they eventually got a hold of the real Mr. Shears, who had no knowledge of this impersonating scheme. And he actually ended up paying out of his own pocket some of these people who had been scammed by this employee. That individual is now been charged, and I believe he's awaiting trial sometime later this year. So that's a little bit of background. Obviously, not managing finances properly and then having to pay back some people, it's obviously affected his cash flow and his bank balance, which caused him to bounce checks and not be able to fulfill some of his contracts. Just to be transparent, we did the discovery, there was a small amount of gambling, online gambling going on, but it's peanuts compared to the approximately a little over $60,000 that's involved in these cases that are before you today. So the bottom line is, unfortunately, all these circumstances led to a even situation. And I know from my prior occupation that people, contractors often get a little bit behind the ball, start using money from the new jobs to pay the old jobs, and that's essentially what happened here. Snowballed out of his control. After he's entirely without blame, he should have handled the situations better with the impersonating scheme. Should have been more forthright with contractors and clients that were waiting for the money. Guidelines score out to be 0 to 11. The probation officer's recommendation, I believe, is 6 months. I would point out that the statute that he's charged with for the contractor charge has some language in it about it's a high court misdemeanor of 6 months to 2.5 years in prison. I did share with the prosecutor a couple of Court of Appeals cases, which I would cite if you want. In those cases, builders took money from clients in excess of what my client did, and put on probation, even though they hadn't paid the restitution back like my client has already. And they ended up getting probation, and then when they didn't pay the restitution, then the jail closed. So I can give you the sites if you want.
You're an officer of the court, Mr. Woody. The court accepts your statement.
He does have, he got property license, set up a new business. He's got about 7 jobs in the pipeline right now, one of which is going on. His business is very much smaller now so that he can handle it. He only has essentially the 1 truck and 2 employees. Obviously, he's learned a lot about how to run a business and how not to run a business. Notwithstanding that, he does take 100% responsibility for the mistakes he made with bad checks and not being able to fulfill his contracts. He apologizes to those suppliers and the customers affected. He did pay a little over $60,000 of restitution, or he borrowed that money from relatives to make it happen. So hopefully, now that you know the full backstory, I would be asking for much less jail time than what's being recommended. Especially in light of the Compass evaluation that indicated that he has no needs to be addressed in all categories. So we're asking for much less, if not no jail imposed at this time. If you do decide to impose some jail, it would be ideal to have it happen on the weekend so he can keep his business running, fulfill the jobs that he's got contracted out now. All right, that's all I have.
Thank you. Is there any objection to 1 pre-sentence report?
No, Your Honor.
Does your client wish to address the court in light of the no contest?
He does.
Go ahead, sir. What would you like to tell the court?
First, I'd like to apologize to the customer if this happened to, if I could. That does so.
You may if you wish.
I just wanted to apologize for this happening. We've done work before for you, and I just hope we could forgive you for this. In light of that, Your Honor, I ran a great business for the last 5 years. I've given back to the community. I'm a part of the Chamber of Commerce, NFIB, National Federation of Independent Businesses. I'm part of the Veteran Heroes News Network, which we donate a roughly year to a veteran in need as well. So again, I'm looking to get back into coaching. Obviously, all of this has affected that, so I've kind of lost my job being a basketball coach, as I have been for the last 10 years. I actually have some interviews lined up for head coaching positions next week. And I learned a lot from this. I have been getting help from a chief financial officer, Terry Lutz for Sure Hospital. He's a dear friend of mine. And I've learned to just handle my finances a lot better with QuickBooks, not just pen and paper. It got out of control. That's too big for me to handle, and I've kind of just lost sight of that. Now I've got everything under control.
Thank you. Mr. Rakowski, anything on behalf of the people, and this is a victim's rights case.
Yes, Your Honor. One of the victims wishes to address the court. Please.
Morning, sir. Would you please state your name for me?
My name is Randy Sturm.
Mr. Sturm, what would you like to tell the court?
I'm a victim of larceny by conversion that occurred on February 16th, 2024 with Mr. Shears. I had a reason not to trust Mr. Shears because we have done jobs in the past. We never had an issue. When he asked for the money up front, I did not question it. He was new company and we needed the money to get building supplies ordered. We gave him a check for $50,000 and he immediately cashed it. At that time, we had also agreed he would start roof as soon as weather became fit in the spring. I believe it is repeated lies why they were unable to come to the job. Spring, summer, and fall was repeatedly told, I'll be there next week. At one time, he told us our building supplies were at Ben's Contracting Center in Marlette, Michigan, just waiting to be delivered. After more excuses, we decided to go to Ben's Contracting Center to see if we could get our building supplies and have someone else do the roof. We already paid up front for the building supplies, but when we went to Ben's Contracting Center, that we found out our building supplies had never been ordered. I feel very lucky to have had my money refunded, but also sad to think that his grandparents are the ones who paid for it. So we do not feel that Mr. Shears has actually made restitution for his crime since the money did not come from him. Thank you, Mr.
Mr. Rakowski, sir.
Your Honor, start with, I've had several conversations with Mr. Sturm while this case is ongoing. The other businesses that were the victims, I had limited contact with them. I would say that what Mr. Rooney had pointed out is true, and that is we have People versus Mitchell. It is down in the district court right now. It's a case that's pending, but none of these files that we have in front of the court involved Mr. Mitchell saying he's Mr. Shears. These were all Mr. Shears cases. The prosecutor's office focused on making sure that all these victims were made whole. And so everybody that had filed a complaint that came forward and talked to the police have been made whole at this point. I would point out though that, Mr. Shears and Mr. Rooney had brought up about the financials and the QuickBooks and all these things, but it really comes down to being honest with your people, because that's what was not happening. And I think that can come through with the conversation that Mr. Sturm just mentioned. That, it's not that, hey, I had somebody else impersonating me, or I needed to have more time because I'm short on money, but I'll make it up and all this. I'm going to be there next week. I got my supplies. When they followed up on it, found out it wasn't true. So just for purposes of the recommendations in this case, we believe the pre-sentence investigation that was put together by the Department of Corrections is accurate. And we ask you to fashion a fair and just sentence based on all the information that you have.
Thank you. One thing about living in a small community is your word, your bond. And as soon as, and businesses have been around for years, new businesses pop up all the time. But at the end of the day, something like this happens, it spreads like wildfire. And it's significant because we trust the people that we engage in. Mr. Stern would have been trusted with Mr. Shears, saying, this is my roof, this is what I need going, okay, here's the amount. I need the money up front, or at least some of it, $50,000 worth. And Mr. Stern followed through with the understanding that Mr. Shears would follow through. That's the whole idea about this. And here in this case, we have an individual with no prior felonies, a year of college under his belt, gainfully employed, and we're talking around $60,000. That's a lot of money. A lot of money. Never mind builder's first source regarding the check or checks. But when someone hands you a check for $50,000, to me, that is really, really significant. They expect something in return. That's the whole idea of contracting with business people, reputable business people, that things get done. And the court understands this Mitchell matter that may be going on, but if I recall correctly in the police report, I believe Mr. Sturm had tried to make contact with Mr. Shears in person, and Mr. Shears walked away from him and walked in the home, if I recall that correctly. And so seeing that a business is getting too big for its britches, so to speak, you know, again, the court understands that, but you're accountable to the people you work with and work for. Mr. Rooney was a former contractor, and a heck of a good one. Why he got in the law, I'll never know, but he did, and he does a good job at it. But at the end of the day, Mr. Rooney understands this as well. You engage in a contract, you have to fulfill the terms of it. And so the court considers that. The court is appreciative of the fact that the victims have been made whole. Now, whether the money came from grandparents or wherever it may have come from, legitimately, of course, at least it puts the victims in a state where, hey, look, I didn't get my roof, I didn't get the things done I needed to get done, I had to go through this headache and heartache, but at least I didn't lose the money. But it's still difficult. It's still difficult because another contractor did more damage happen because the roof didn't get repaired. A lot of things play into this. And when the court considers all of this, I mean, I'm just thinking as an individual myself, I contract with people, whether it be water heaters, furnaces, roofing, whatever, we have to do those things, and you expect them to be there and be accountable. Mr. Shears has a very good record, at least no prior felonies, understands the misdemeanors, but an educated man on top of it. But he has to pay the piper for what he has done here. And I understand. It will be the sentence of this court relative to both files. Both files, the defendant is placed on a term of probation for a period of 12 months. Conditions of probation include the standard conditions: not to violate any criminal law of any of the government, not to leave the state of Michigan without prior approval of the court, notifying the probation agent at least monthly or such times and places the agent may require. He's to complete, and this applies in both files, complete unless stated otherwise. Complete the Thinking Matters program, waive confidentiality, and allow any treatment program he's required to attend to disclose that information to the agent. He's not to have any verbal, written, electronic, or physical contact with Randall Sturm and builder's first source, either directly or through another person. Can't be within 500 feet of the residence, school, or place of employment or business. Not to engage in any assaultive, abusive, threatening, or intimidating behavior. Not to have any verbal, written, electronic, or physical contact without permission of the agent with anyone that's housed within an NDOC facility, nor the same type of interaction with anyone that's engaged in a behavior that constitutes a violation of any criminal law of any government. Now, as a convicted felon, he must not use any object as a weapon, cannot own, use, or have under his control a weapon of any type, not even an imitation. Can't be around anyone that possesses those items. He's contacted the supervising field agent no later than the first business day following his placement on probation or release from jail. Comply with all written and verbal orders of the agent. Allow the agent to his residence at any time for probation supervision, where he's subject to a search of his person and property, including but not limited to his home, vehicle, or computer without the need of a warrant if the agent has reasonable cause to use items that violate the terms of his probation. Any arrest or police contact, loss of employment, or change of residence must be reported to the field agent within 24 hours, weekends and holidays accepted. He's to make genuine effort, though gainfully employed, to find and maintain legitimate employment, minimum of 30 hours per week, and follow all the terms and conditions therein. He's also paid in each file crime victims assessment. Well, actually, crime victims assessment of $130 will be ordered. In each file, 130 in each file. It says. 130 in each file. Probation supervision fee, $30 per month regular, $60 electronic. Court costs in each file of $200, payable at the rate of $20 a month. A fine. Fine of $1,000 in file number 1, the first file, it should say. Attorney fees are waived. $68 in state costs in each file. Probation is empowered and authorized under statute to effect his apprehension, detention, and confinement of up to 72 hours on reasonable cause he violated the terms of his probation. He's to successfully complete any PA 511 programming based upon eligibility. The court is aware of the minimums here relative to count 1 as well. Guideline range is 0 to 11. And frankly, I find the recommendation is appropriate. The defendant shall serve 180 days in the county jail. Credit for 1 day previously served. He is eligible for PA 511 program and work release, so long as it comports with the Sheriff's Department guidelines relative to work release. And those shall run concurrently with each other. Is everyone doing the court minutes?
In regard to jail credit, you only get the jail credit on the file.
Second file. You're right. So credit on the second file, not the first file. My duty to inform the defendant he has right to seek leave to appeal. If he's financially able to provide counsel of his own choice, court will assign counsel form at public expense. He's to initial the receipt and questionnaire form requesting the assignment of counsel, both of which must be executed under oath and filed with the court within 42 days.
As far as the report date, Your Honor, since he has his job in process right now.
What time is it complete work today?
Five, 6 o'clock. 5.
Where's the job at?
Caseyville.
Caseyville? Reports to the county jail by 7 p.m. this evening. Good luck to you, sir. That'll be off the record. Thank you.
Okie dokie, friends, we march onward here at TCF Live. I hope you're all enjoying your morning. Let's go back to Texas and Judge Stevens.
Well, CR 889 is now called the state of Texas versus Darwin Alvin James McMillan. And you were here with Mr. Dusler, your attorney and the state's attorney. Does the defendant waive a formal reading of this motion to revoke probation filed February 2nd of this year? Does he proceed in summary?
Yes, sir.
Raise your right hand, sir. Do you solemnly swear or affirm any statement you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Lower your. In summary, sir, this motion to revoke probation, which was again filed on February 2nd of this year, it states that on July 23rd, 2024, in this Criminal District Court of Jefferson County, Texas, you were sentenced to 10 years in prison, and that was suspended, and you were placed on 10 years regular probation for the second-degree felony of burglary of a habitation. Is all of that true and correct? Allegation 1 states you committed the offense of theft of property on or about December 10th, 2025 in Jefferson County, Texas, which violates condition 1 of your probation order, and condition 1 of all probation orders state don't commit another crime. Is that allegation true?
Yes, sir.
Are you pleading true voluntarily and because it is true as it is alleged? Yes.
Yes, sir.
You understand that a voluntarily and knowingly made plea of true to one or more violations of probation. That's enough to grant a motion to revoke probation by a preponderance of the evidence or greater. Your probation can be revoked. You can be sentenced to no less than 2 nor more than 10 years confinement in prison. Knowing that, do you insist on pleading true to them?
Yes, sir.
Find you're pleading true voluntarily. You understand and appreciate the consequences of pleading true. Yes, I was looking at this. When we placed you on probation, which was heading toward 2 years now, I ordered you to pay $1,000 in restitution to the victim in this case, which is the owner of the home that you burglarized. Did you pay that back? No,
No, sir.
you didn't. How much did you pay? 1 penny?
No, sir. You make a payment.
How much did he pay back in restitution from probation? Because I don't believe what he said.
A total of 650 was made recently.
Remained
Remaining, he has
350. Oh, you know how much that comes out to, like per month? How much?
110.
No, $15 a month.
You've been
15.
paying the 110 total with your fees and everything.
I would make $103 payments, and then I probably was short 3 or 4 payments, but the rest I made sure they was full.
Okay.
And I was.
What's the agreement on this?
There is no agreement.
Stand by. Hold on, let me read this. Just a second. You're gonna get a chance to speak. Don't worry. This probable cause affidavit doesn't help me at all about the underlying burglary. It doesn't even talk about a burglary. Do you want? It's something else altogether. Yeah, the pre-sentence on it. we have to purge these from my file with them. Thank you. Okay. Yes, sir. Now, this new offense. Right, according to the probable cause affidavit here, you stole a jacket at Dillard's, is that right?
Yes.
And you had been convicted of burglary of an habitation. Where you had broken in and stole some stuff from a home, right? Yes. Oh. Go ahead.
Well, Judge, we do not have an agreement on this. He, to my knowledge, he doesn't have any other criminal history that we've dealt with since he was placed on probation a couple of years ago. He accepts responsibility for this.
He did?
Well, he has history. While he has not,
He does have criminal history.
well, I said since his offense.
Okay. Was he
Okay.
placed on illegal possession of marijuana in 2019? It was deferred and he was discharged. Then another deferred probation accident involving damage to a vehicle in 22. And that was 12 months deferred. Is he still on probation for that? Because there was a restitution, it states an active case. He's not, that was closed somehow? Because there was $2,385 in restitution. Of course, when that would remain open if he could pay restitution sometimes. And that was in 22, a few years ago, but do we know what happened on that? It doesn't show that it was revoked, but did the people get paid? I mean, the decent thing, did they get paid back their money?
Yes, I believe so. They did.
You know how much I would believe you? I don't, because you've lied. I'm looking, you lie and you steal. That's what you do. And I mean, you stole here at Dillard's, and this burglary, you broke into somebody's home and stole stuff from them. And let's see. And when the officers, what are you doing in the backyard on the burglary? I'm looking for a piece of equipment that goes to that SUV. Why would you be needing to look in the backyard for an SUV part? And then you've decided not to say anything since they caught you in that lie.
Your Honor,
What's burglary of a habitation? That was the burglary of habitation. You pleaded guilty to that. You weren't guilty of that?
yes, sir.
Yeah, because you pleaded guilty under oath by breaking and entering with the intent to commit that.
May I continue?
You may.
Thank you. Judge, I think that what he's done is he's shown good faith by making payments on this. He's done a portion of his community service. He's been making payments towards the restitution.
How much is the restitution?
He's paid $650 out of 1,000.
That's right, $350. Yeah.
So it's $350 left. And he realizes that he made a mistake by doing a shoplift, but he's asking the court to hold this matter in abeyance or reinstate him at this time. Let him continue to make payments so we can get all the restitution finalized. And he tells me that he thinks he can successfully complete probation without any new offenses.
And what's that saying?
Judge, when you look at the administrative hearing that was filed in December after this theft, you'll notice that it still says the defendant owes $1,000 in restitution. So after he gets arrested for this, then when he knows he's coming up for a sentencing on this and facing this, then he makes a payment towards the restitution.
Where'd that money come from?
So
the money that you pay.
Unemployment. I get paid every 2 weeks. Unemployment. Then he goes and steals at Dillard's, which is what he was accused of doing before stealing. So it's a similar crime. He just didn't break into somewhere to get it. He just walked in, took it, and was walking out.
Did the clothing get returned?
Yes, and the one at Dillard's, they caught him outside the parking lot and returned it to the store. So there's no restitution there.
God bless you.
But you can't just get on probation, commit another offense, and expect to just walk out of here unscathed. So we'd recommend 5 years prison time.
Anything else?
No, sir.
I've got another idea because I want these people paid back. And you on probation here for 10 years from July of 2024. So you hadn't even gotten to 2 years yet. You still have over 8 years on probation. So how do you pay this restitution back when you get your money?
I will make a payment. I'll be released, Your Honor. I will make a payment of another $500 and then stay on top.
How do you do it if you're in jail, though? How are you able to do it if you're in jail? Because I want these people paid back. As you go to prison, you'll never pay it back. I want these people paid back.
I would lose my unemployment if I was to go to jail.
Why's that?
I would have to call them.
Oh.
Yes, apply for my benefits like that. And so, and I have money saved up, I can pay it as well.
What do you mean by that?
Like from working, and I have a job waiting on me to be released at PSC.
Where's the money?
Sir.
Where's the money, the $350 that needs to get paid? Where is that sitting right now?
At my house.
Huh?
At my house.
Okay. How can you get somebody to get it to pay back for restitution?
Sure.
How can you get it to the probation office?
I contacted my mother. I can say something wrong?
Mm-hmm.
I want to say, my mom made a bad decision.
Which time? You made a series of bad decisions.
And I want to say, I've been completely drug-free, never failed a drug test. And I've been on the right track. I'm going to stay on the right track. I have 2 jobs waiting on me. I have a close family member breaking me in McDermott Refineries. And I have PSC as a warehouse technician with all my qualifications on my TWIC card and ISTC badge.
You committed theft just a few months ago while on probation. How do you explain that?
Dumb decision.
Sir?
It was a dumb decision. And I was talking.
I think we all agree with that.
I'm here to say, Your Honor, I'll get in any more trouble. You got the right to do anything you want with me. I'm going
Thank you for setting the rules.
No, sir. No, sir.
No, that's what you're telling me. You're gonna decide how I will act
No, sir.
during this? No, that's your problem. You dictate on your rules. You don't follow the rules of law.
And I'm going to stay on the narrow track, stay on the right track, continue making my payments, and finish my community service so I can put this probation behind me.
All right. yeah, what I'm going to do is, ok- there is sufficient evidence supporting this motion by the evidence presented here to show by a preponderance of the evidence or greater, beyond a reasonable doubt, that you committed an offense of theft on or about December 10th, 2025 in Jefferson County, Texas, which is a violation of condition 1 of your probation order. I am going to do this, though, because you still have some things to do. You've been convicted. I'm going to hold anything in abeyance for 2 weeks to give you time to get the money in the restitution to those people. And then I'll pick this up where we left off. You got 2 weeks to get somebody to get your money to pay these people back on this restitution before I do what I do next, what I'm going to do next, which can be up to 10 years in prison, which is in the front of my mind right now based upon your actions. So I'm going to see what happens in 2 weeks and then we'll pick this up. Okay. So it's held in abeyance and there is no bond. You can't be released from jail. And we'll find out if you were able to repay this back and we'll see what happens then. Do you understand, sir? All right, reset 2 weeks. Thanks.
I'm immediate. That shows you the reset.
Satara?
Satara speaks Spanish. We're waiting for an interpreter to help me there. Okay.
Alrighty, friends, TCF Live. It's Monday. My name is Dan. It's good to have you here with me as we enter our final hour of the show. Per our channel's promise, 9 to 11% more Judge Boyd. Let's go there.
Duty on striking fixture highway landscape. There's always something where I have to look up. I'm not up to date on misdemeanor. All the
It's a B.
Yeah. Okay. All right. So are we here today for sentencing?
Yes, Judge.
Excuse me, on Simanski, I don't have any of the paperwork.
You want to look at the,
Yeah. It's for sentencing. Is there any objections to me ruining it?
no, I figured you already had.
No, I usually don't do that until attorneys have a chance to review everything and then they can tell me whether they object to me.
No, we don't object. We didn't find anything factually incorrect.
Oh, you don't have to file stamp it because it's not a plea. It's a sentencing.
Well, I have paperwork for that.
No, I mean, I need to see what the plea agreement was reached because it's a sentencing. Yeah. All right, thank you.
Yes, sir.
Oh, thank you, Judge.
Thank you. All right, the court is calling 2025 CR 0064220 State versus Corbin Simanski. Can I have parties announced?
For the state.
Charles Buck and Clint Glennie for the defendant.
All right, and are you Mr. Simanski?
Yes, ma'am.
All right, you entered a plea on, it looks like January 13th, according to your plea bargaining agreement. state is opposed to your application. There's a $2,000 fine, cap of 6 years in the prison, and restitution to the complainant. Have both parties had a chance to review the PSI report and TAP evaluation?
Yes, Your Honor, and no objections for the state.
We have reviewed the same and have no objections.
All right, are there any witnesses? State?
No witnesses, just argument, Your Honor.
No witnesses, just discussion.
Oh, a discussion? All right.
We don't want to argue with anybody.
Yeah, there's no argument, just a discussion. All right, then let's discuss. State, you're opposed.
I am, and so we're asking that you deny the application, Your Honor, and that's based on some of the things that are contained within stipulations. And so in reviewing the defendant's PSI, what was reported to the PSI officer is that he was not under the influence of alcohol. He was the designated driver on the day of the offense, and that the reason that he became engaged in this altercation that was ongoing is because a member of his party engaged in a verbal altercation with the complainant in this case. And then what is reported is that the complainant then dropped the driver's side mirror of the vehicle that the defendant was operating. And then at this point, the defendant grabbed the firearm and began holding it. And then he reported that the complainant walked over to the vehicle again. And that's when he fired the firearm and struck the complainant in his abdomen. And if we look at the evidence that was stipulated to, that rendition is in stark contrast to what was reported by witnesses that were present that stated that they were crossing the street when the defendant began calling out to them, making offensive statements to them, and then followed them in his motor vehicle. And then at that time, that is when the person or the passenger in the defendant's vehicle got out of the vehicle and engaged in the verbal dispute with the complainant. And it's stated and stipulated to evidence that the complainant attempted to cross the street when the defendant cut them off in the truck and brandished his firearm. And then there is this regarding the truck that the complainant did strike the truck, and then that is when the defendant shot at the complainant. And so the state's position is that no deadly force was exhibited against the defendant, and that he was not justified in using force, and that the force that he used was unreasonable and exceeded the scope needed if he's stating that he was in fear, like what he stated to the case officer.
All right, defense.
Judge, yes, yes, that is what's in the stipulated evidence, and we pled no contest to that evidence. I think what the court knows from having been in this position for a long time is there's usually a lot more to a story, and I believe that when you look at what the evidence says and what my client said in the PSI, I think that kind of gives you a complete picture of what was going on. It all started from an argument between my client's girlfriend and the defendant and the group of people the defendant was with. It was two groups of people, which escalated to the point to where there was a almost physical altercation between another gentleman who was with my client and the defendant. And at that time, the defendant, kind of addressed the situation. The complainant, as Ms. Galloway spoke of, approaches the vehicle. There's discussions, there's some types of physical contact. At which point my client eventually then does,
When you
commits
say
the crime.
physical contact, you mean
The
physical
striking of-
contact with this vehicle?
Well, my client, as the PSI reflects, that the defendant was struck at some point by the complainant. And when Ms. Galloway talks about the complainant striking first the mirror of the defendant's vehicle, and then the second time when the defendant then strikes the rear of my client's vehicle. But no, there was not an actual fight, if you will, between my client and the defendant, other than the the verbal discussions and then the allegation my client makes that there was some contact between the defendant and my client. And then, as Ms. Galloway pointed out, between the defendant vehicle and the complainant multiple times. But unfortunately, this led to the event that occurred. And we're certainly not here. Like I said, we've pled no contest. We're accepting responsibility for what happened. But just as the court is aware, there's always more to the story, if you will. It's not just a situation where unprovoked, my client just acted out. But I also want to address, if I may, that, you know, this allowed, or it gave my client some clarity and helped turn around what had been a difficult situation for him. Since the court was generous enough to reset this PSI to allow him to complete the inpatient program at Lifetime Recovery. And I've shown to Ms. Galloway the certificate of that. He got out, he did the 2 months inpatient at Lifetime Recovery. And I can show, I have that for the court if the court wants to see it.
Any objection?
So we want the court to certainly know that my client understands the direness of the situation, but also understands that even though he wasn't drinking that night, the court can see from the PSI that he has an issue with drinking and that needed to be addressed. And that also helped some other situations that he'd struggled with early in life that have now been addressed through his counseling and work with Lifetime Recovery. So we dealt with not only the alcohol issue, but also some mental health issues that needed to be addressed. So he, in a very sad but strange way, this kind of helped him realize, you know, we got to make some changes. So as the court is aware, you know, he took it upon himself to be proactive and do these things in an attempt to show the court he takes this seriously and he understands the gravity of the situation. Now, certainly, as the court said, it's a cap of 6 opposed. We're asking the court to consider and grant his application for deferred adjudication. We had lengthy discussions. You can see how many times the plea was reset because we discussed with our client over and over the easy way out, if you will. You know, we can get you a couple of years, you can be done and put this thing behind you. He didn't want the easy way out. He wants the hard way out. He wants to prove to the court, to the family of the complainant, to his mom and dad, who are also present in the courtroom, that he's better than the Corbin Simanski that was seen on that night. And we believe that the deferred adjudication will, one, in the PSI, there talks about unpaid restitution. That's certainly something that can be addressed, and I expect would be addressed if the court was to consider his application for deferred adjudication. And furthermore, we understand that the court can place him on deferred with very intensive conditions, and I certainly expect that the court would if the court was to give him this chance. We believe the totality of the circumstances, when you look at everything, he's a great candidate for deferred adjudication. I think that he would prosper. I think he'll show the court that he was worthy of the opportunity. I know from dealing with Mr. Simanski personally, he certainly understands the gravity of the situation. If he could go back to that night and not have interjected himself into other people's problems, he would love that opportunity, but we can't go back. So all we can do is go forward, and we're hoping that in going forward, he can get the deferred adjudication. As you can see, he doesn't have any criminal history prior to this. He had and still has a very good job that will allow him to assist with this restitution that the complainant certainly is entitled to. I think he's an excellent candidate. I'm asking the court to consider his application for deferred adjudication.
Okay, I don't know why people think that weapons solve problems. That's what I'm trying to understand. People are in an argument, somebody pulls a gun, nobody else has a gun. What's the point?
That created the problem.
You'll raise your right hand. Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Corbin Simanski. I was being followed for 2 blocks.
downtown where that red statue is, you have to take a UE to get out there.
So let me ask you this question. If somebody's following you, they don't have a gun, and you have a gun, do you think it's okay to fire at them? That's the question. Again, I don't understand why everybody wants to have a gun. Nobody takes classes on guns. People just pull them randomly. It's sort of like, I took a lot of psychology courses. I should have double majored, but I did it because I took political science and you have all these electives. I said, let me take psychology. It may come in handy. And what I've discovered in my time and everything that I've viewed in this life that I have, one, when people are with groups of people and somebody does something stupid, then everybody jumps in because it's a group of people. And sometimes when you're by yourself, you would not have made the choices you made. The other thing that I've discovered is when somebody has a weapon, they always want to pull it. So I'm just trying to get into your psyche to understand what you think of this whole incident.
Very scarred from it. I actually still have nightmares from it. I don't ever want to touch a weapon.
Nightmares about what?
That night, and the fact that I hurt somebody and that I hurt somebody very badly.
Do you have weapons at your home?
No, ma'am. Not, I have pocket knives for work. That's it.
Mhm. And where do you work and what do you do?
Native American contracting, doing ironwork.
And how long you've been working there?
Since January. I was working at GSI, but it's a mountain stabilization company. And with the whole court stuff, they want me to come back, but I can't because I obviously have appointments in court and it's an out-of-state job.
Okay.
Judge, for whatever it's worth, I want to point out that that he did remain at the location when the police got there, he cooperated and complied with all their requests. So I didn't point that out earlier. I wanted to make sure that was pointed out.
All right. Anything from the state?
Okay, Mr. Simanski, so you stated that you all were on Market Street by that red statue with the roundabout, is that correct?
Passing the red statue, we were at the first light, I believe. It was a long time ago. We were at the first light, and then an old friend that I don't even associate with anymore was saying something to him on the sidewalk. And then he comes to the truck, was beating on the truck, and then gets into an altercation with my friend. And then comes over to my side of the truck because I was telling him to leave us alone, and kept.
All right. And I'm so sorry. Just for my clarification, when you say altercation, what do you mean by altercation? Verbal, physical?
Verbal at the moment until he came, because I was telling him to leave us alone. He told me to shut up and came over and punched me. And then he was talking, running his mouth outside of the truck, like just provoking and provoking and provoking.
I'm sorry. Did you say he punched me?
Yes, ma'am.
Okay. And I'm sorry for interrupting I'm just trying to understand what he's saying.
So I kind of want to back up a little bit because you stated that the complainants were following you. Is that what you said?
Yes, ma'am.
Okay. And so at this time, they're walking, correct?
Yes, ma'am.
They don't have any deadly weapons, do they? Okay, and you're in a motor vehicle, correct?
Yes, ma'am.
Okay, and the motor vehicle that you're in is pretty big motor vehicle, right? It's a big truck, right?
Yes.
Okay. And so what some witnesses say is that they were attempting to cross the street and you became angry and that you're the one that started calling them names. So you're saying that's not true? I
put this on my life. I'm not the one that provoked this situation to begin with at all.
So your testimony is that that was your friend that was engaging in a verbal altercation with the complainants and calling them names?
Yes, and he actually ran from the scene.
And I'm not disputing, you did say you were cooperative with the police officers. I'm not disputing that. I'm just trying to clarify what occurred that night, okay?
Yes, ma'am.
And so then when the complainant approaches the truck that you're driving, at that point, did you become angry and that's why you produced your weapon or what?
I was frustrated because the girlfriend was standing in front of the truck. He was standing on the side. We did drive up probably 20 feet. We were in the turn lane and they were following us, screaming at us. The only reason I didn't drive off from the scene is because my friend was out of the truck and I didn't want to leave my friend downtown.
All right, and I'm sorry, is there something going on outside? All right, thank you. And I'm sorry, the friend that you're saying you didn't want to leave, is that the friend who ended up leaving?
He ended up leaving him, yes.
Okay. All right, is there anything else?
Nothing further, Judge.
All right. Let me just tell you, I can understand how sometimes things get out of control and some things people could not foresee. I'm gonna give you a choice. These are your choices. There are no other choices. Don't ask for any other choice. This is your only choice. One, I can grant your application for deferred adjudication, but you are going to do jail time as a condition. Or two, I won't I will not grant your application and I'll sentence you to 2 years in the prison. Do you need to speak to your attorneys?
I want the deferred adjudication.
You all want to?
No, Judge, we addressed the possibility of this situation and we discussed all the pros and cons and he absolutely, as I stated earlier, wants to prove to the court, to the complainant, to his parents that he's not that person and he's worthy of this opportunity.
All right.
Can I say one more thing?
Sure.
I did find out last night that
That he may have a child on the way. Yes.
Okay. All right. Here's the thing about children on the way. I always tell people, if you have situations that are going on in your life where you have no control over the outcome in the sense that you're before the judge, I don't know why people go forth and like, I'm going to have a child. It's like, you could be going to prison. All right. So first off, Norma, I need a reset date for restitution hearing. And state how much time you need.
Judge, so plus 45 days, so that is something that I wanted to address. We have got the complainant in communication with the Crime Victims Compensation Fund. However, it's my understanding that they did not cover the totality of the medical bill. And so at this time, we're in communication with Beyonce to try to obtain certified copies of what's remaining of the medical.
All right, Ms. Ferguson,
Yeah.
recall this for 60 days for a restitution hearing. And on the record, because it's going to be a long date, does anyone have any objection to recalling this for a restitution hearing in 60 days?
No.
All right, what date? So June 11th will be your restitution hearing date. This is what the court is going to do in this case. The court is going to sentence you to 8 years deferred adjudication. There's an affirmative finding of a deadly weapon. $2,000 fine. That will be probated. 200 hours of community service restitution. I'm going to order anger management. Once anger management is completed, 100 hours of the community service restitution will be deemed satisfied. Probation, is there any other class that he would need? All right. There's going to be regular reporting by Zoom or in person, regular random UAs or the patch. Proof of employment within 45 days of release. No employment as a home health care provider or with minors. Oh, Vashon, he's going to need parenting classes since he has a baby on the way. The remaining 100 hours will be deemed satisfied upon completion of parenting classes. And Ms. Abrams, if you'll note in your file that he has previously completed lifetime recovery, there's going to be field visits 1 time per month for 6 months. And there's to be restitution, if any, and no contact with Devin Winkler Santana. There's to be no possession of firearms. Probation, anything else? All right, let's do the cognitive behavioral course. All right, and there's to be 60 days in the Bear County Jail as a condition of probation. Is there anything else you need from the court?
No.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Say yes.
Yes, ma'am.
All right. Because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. All right, we can go off the record. Here's the thing. You need to make sure that you complete everything and you do everything appropriately. You understand?
Yes, ma'am.
All right, good luck to you. Thank you.
Thank you.
You're welcome.
Sad but true. We've been through this many times. His odds of completing 8 years deferred, incredibly small. We'll see, but I think he'll be back. The odds prove it. Unfortunately, we won't see it because there's no way Judge Boyd's replacement is going to be streaming. Anyways, Huron County, Michigan. Let's go back to Judge Prill.
Cheyenne Candy Phillips, 247166 FH, time and date set for probation violation hearing. Defendant is present, represented by Attorney Elizabeth B. Weisenbach. People are represented by Prosecuting Attorney Timothy J. Rakowski. The court had a brief sidebar with counsel regarding the status of the matter. It appears that a plea agreement has been reached relative to probation violation allegations on or about September 10, 2025. And also, we're going to address the defendant's alleged failed to appear on that date for arraignment. Ms. Phillips, as best you can, would you please raise your right hand?
You solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God.
Thank you. Mr. Rakowski.
Sir, my understanding that Ms. Phillips would be pleading to count 1, 2, and 3 and count 5. People agreed to dismiss count 4, and we would not be seeking any type of charge for the failure to appear.
Ms. Weisenbach, is that your understanding?
Right.
And Ms. Alexander, is that your understanding? Okay. Ms. Phillips, did you hear the terms of the plea offer outlined just a moment ago?
Yes, Your Honor.
Is that your understanding of the plea offer?
Yes, Your
Do
Honor.
you wish to accept it?
Yes, Your Honor.
Are there any other terms to the offer that we've not disclosed on this record?
No, Your Honor.
Mr. Rakowski?
No other terms.
Thank you. Ms. Weisenbach?
Agreed.
All right. Count 1 alleges failing to attend any treatment programming. Count 2 alleges failure to enroll in any mental health treatment. Count 3, failing to enroll in anger management. And finally, count 5, failing to report to the Lapeer Probation Department on September 3, 2025. Ms. Phillips, what are your pleas relative to those counts?
Guilty.
So you failed to do those things?
Yes, Your Honor.
Probation, the court takes judicial notice of the probation order, which indicates those programs were ordered. Is there any explanation as to why you didn't do any of these things?
Yes, Your Honor. There's a letter that I wrote to you to explain why. We could read this in the sentencing piece.
Okay.
But I can
Court-
answer a couple of questions with regards to answer your question.
And that's fine. And the court will not read any ex parte letters. So I have no idea what the letter may be.
Oh, no, she's gonna read to you.
At the time, right.
Right.
I thought she said she sent one.
No, right here.
She has one there. Okay. All right. So
So if I can address your question by asking her a couple. it'll
Sure, go
make it
ahead.
Easier, okay, all right. There was a time when you were in this court and you released rights to your 2 little girls, correct? Yes. That was devastating. Very. You went into a black hole, didn't you? Yes. You didn't do anything? No. None of this stuff? No. I think that answers the court's question. We can give more detail in this moment.
Does that also explain your failure to appear in court?
Yes, Your Honor. I went into the mental hospital.
As stated, the court takes judicial notice of the file and the probationary conditions. Is anyone forcing you into this arrangement, miss?
No, Your Honor.
Anyone threatening you?
No, Your Honor.
Is this your own free choice?
Yes, Your Honor.
And you recall all the rights that were provided to you previously when you signed the advice of rights form relative to probation violation?
Yes, Your Honor.
Court will accept the plea. It's done freely, it's voluntary, understanding, and accurate. There's a sufficient factual basis. Do you have a recommendation at this time?
I do have a recommendation ready.
Go ahead.
She's to enter into the TRICAT methamphetamine program, must serve a minimum of 10 days in jail prior to being approved for TRICAT programming. Remain on probation with all conditions to remain in effect.
All right. Ms. Weisbach, do you wish to proceed to disposition?
Yes.
Anything you'd like to say on behalf of your client before the court imposes sentence?
Thank you, Your Honor. I have represented Cheyenne Goet and Cheyenne Phillips, and this isn't the first time that she has released rights to children. So it's been a long haul, and it's painful for her. Those 2 little girls, we actually got books so that she could read to them from her jail cell, and she wanted to try really hard to get her girls back. So when she was released from jail from the prior situation, then she went into a shelter in Mount Pleasant. Went to see her there. She was at be on track. She went to a shelter in Lapeer. She shifted that around. She felt that was DHS's pushing her this, that, and the other. So when she was at the Lapeer shelter, she again was trying. Transportation is a problem. Getting a job with a felon is a problem. Just everything is really hard. And it doesn't help when you have mental health issues and possible substance abuse issues and lingering in the background always and forcing himself into the forefront with Brian, the father of the girl. So all of these things compounded and made it really hard. One thing that she was able to do was to get a home using the resources in the Lapeer County, through the Wakata and whatever else that they have. So she did get a home, but then she went into the black hole, and as we just described a little bit to you. So she has been hospitalized. She has had police reports. She has had poor relationship situations. There's a pile. Her sister brought today paperwork that involves some police reports, that involves hospital stay information, things to that effect. I know you can just believe us from us telling you this. So what she needs and what she's asking for at this point is for the rehab. Ms. Alexander talked to her about the TRICAT previously. I talked to her a little bit more about it, and that is the direction that she really wants to go. So this is working out to be the perfect storm for her to get the break that she needs. With that, she does have a letter to explain a little bit more to you.
Ms. Phillips, go ahead.
Honorable Judge Prill, I am standing before you today on a guilty charge of non-compliance of probation. I am not afraid to admit that, yes, I am guilty to these counts. If you can remember correctly, back almost the same time the charge had started, one was around the time that I lost my only things that I had ever showed me what any type of love was, and that, Your Honor, was my children. If you're any type of human, mother, or parent in your right mind, that kind of pain will never go away. Your Honor, I'm sorry, but I lost my little bit of what hope I had left in me of knowing what real love felt like. When I signed my right to operate in front of you, Your Honor, and handed over the paper before you to do what's best for my children, is when something snapped in my brain and everything started spiraling downhill from there. So to cope with my voices in my head of my children, or the flashbacks of my children being with me, I found the only thing that I thought at that time would numb me from everything I had feeling for, and that, Your Honor, was methamphetamine. No, Your Honor, I cannot. No, Your Honor, I am not saying that was right of me by any means, but at that time, it was the only way that I was staying sane without committing suicide. By the time I realized that was not okay, I was too deep into it. I went in and out of the hospitals trying to seek help. And all they were doing was sticking me in the psych ward for 5 to 6 days and sending me home with medication that did not numb the pain. So I started the cycle over and over and over again. I finally realized now, after 2 months sober, the pain of losing my children will never go away. And all I can do is accept it and move on from what I can't change, but learn from the consequences. Your Honor, what I did to cope was not a way to do it. I have no real support, and I really never have. If you have any type of feeling in your heart, you would understand the pain I am going through. All I'm asking for today is a little bit of your help and guidance to know how to live substance free. Could you please take what I asked in consideration and place me in rehab? Thank you, Your Honor, for listening.
You're welcome. Mr. Rakowski, anything you have to?
Your Honor, we agree with Agent Alexander's recommendations and we ask you to adopt them.
Well, this court has had the opportunity personally, along with court staff and probation agents, to attend this program. And the TRICAT program is rather in-depth program. It's not for the weary, so to speak. And there are a lot of parameters and a lot of requirements involved with it. But after review of that program, there are a lot of great things that are available to an individual with substance use disorder. That's one thing. I mean, obviously you have to pay the piper for what happened here. And reviewing the file, not appearing in court, not appearing to your probation agent, it just compounds it, makes it worse and worse. But by your letter, it indicates to the court that you're seeing that, and it appears you have family support in the courtroom as well. So that helps as well. Therefore, it will be the sense of this court that probation will continue in this matter. You're to remain on the terms of your probation. The court will also order that you attend and successfully complete the TRICAT program. Now, you must be lodged in the county jail here for at least 10 days in a row, as I understand it, to be cleared to go to TRICAT. So I'm getting a nod from probation. So once that is all set up and completed, you'll attend the TRICAT program, and the understanding is stay in the program, get the work done. It's going to be a lot of effort on your part, but hopefully we can turn this thing around. I can't excuse your behavior. Obviously, we still have jail time held in advance at this point. The court could order that today too, but let's see how this goes. If you successfully complete the program, let's say you're there for the program. Let's say you stayed 6 months, hypothetically. If you stayed there 6 months, successfully complete the program, the court would take that into consideration relative to the time you have remaining that could be owed to this court. But you have to stay there. You have to be engaged. If reports come back that you're not engaged and you're just merely following through with nothing, you'll be brought back before the court and we could be talking about jail and or prison. I don't want to do that. I don't think you do either.
No, Your Honor.
My duty to inform you of the right to seek leave to appeal. If you're financially able to provide counsel of your own choice, court will assign counsel for you at public expense. Please initial the receipt questionnaire form requesting the assignment of counsel, both of which must be executed under oath and filed with the clerk of the court within 42 days. "10 days in jail right now." Yep. And then, go ahead.
I was gonna ask that question. She has, until the 4/21. Well, the 4/21, if she's serving time right now, she's under sentence. So technically probation cannot give her those 10 days credit. The courts could, but she has to serve until 4/21 on a fine and prosecute case from Mr.
In another court.
Yes.
And that's what? 8 days away. Correct?
Yes.
Do we need to order a jail sentence here?
If the court would allow, I'm not able to give her the 10 days credit due to her being under sentence.
Well, I'm not giving her the 10 days credit. She has to serve the 10 days.
Right, and she'll actually have those 10 days in, on the 21st, she'll have those 10 days in.
Great.
Allow.
How many days are held in advance?
She has 96 credit, I think it was.
$269.
Okay, I'm gonna order 269 days in the county jail, which are left as stated. As soon as you are able, for 10 days, after that, you can be sent to the TRICAP program. Anytime that you serve at TRICAP that is successful, you successfully complete the program, those days can be credited off your sentence. The purpose of keeping you under sentence as well is if you decide that you'd just rather leave, then you just report right back to the jail and serve your time. You understand that?
Yes, Your Honor.
Does that make sense for you?
260.
Yes. 0 days credit.
Okay, thank you.
Yep.
That's all I need.
Good luck to you. Off the record.
Okay, friends, back to Texas and Judge Stevens.
That happened in this room. I'd be Donald Trump or something in my finances. All right, 26 CR 357 is called the State of Texas versus Deuce Den Tran.
Yes, sir.
Ciao. Good to see you. You were here with Don Dusler, your attorney,
Yes.
and you were charged with a state jail felony. Let me ask, what is this on the indictment? On the caption of the indictment right here, what does that mean?
To be clear, it says TRN.
Yeah.
That's a tracking number, Jeff.
Yeah, that's just what we
Okay.
did to the study.
There's no number.
Well,
It's a work.
All right.
It's a work in progress,
Yeah.
Jeff.
it does many handle, before we get it.
Does he waive a formal reading of this? Can we proceed?
Yes, sir.
In summary, Mr. Tran,
So
this indictment states that on or about January 9th, 2026, just a couple of months ago,
yes,
in Jefferson County, Texas, you committed the state jail felony of burglary of a building. Do you understand what you are charged with?
yes, sir.
This is a state jail felony, which means if convicted, you face confinement in a state jail for any term of not less than 180 days, 6 months, nor more than 2 years. In addition, you could be assessed a fine up to $10,000. Do you understand the punishment range for a state jail felony such as this one?
Yes, sir.
An agreement has been reached, though, where you would be pleading guilty, not found guilty, placed on deferred or unadjudicated probation, which can be up to 5 years in length, fined $500. Is there any restitution?
No, sir.
Is that your understanding of the agreement?
Yes, sir.
If I follow this agreement, sir, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this? Guilty or not guilty? Sir, are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
Yes, sir.
I show you what's marked as State's Exhibit 1. Did you sign that document?
Yes, sir.
Understand it. Discuss it with your attorney. Are the contents all true and correct?
Yes.
State's Exhibit 1 tendered into evidence
Yes, sir.
without objection admitted. This states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged
Yes, sir.
and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, and you were totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God.
Yes, sir.
State's Exhibit 1 is part of the record for all purposes. Pre-sentence report is.
Yes, sir.
If nothing further, I'm going to follow this agreement. I will make the findings that we just went over, that you agreed to, that you are mentally competent to enter your guilty plea. It is freely and voluntarily made. You are giving up your rights as a defendant here of what we discussed about. There is sufficient evidence supporting your guilty plea to find you guilty beyond a reasonable doubt. But I'm going to instead defer or postpone any finding of guilt. So long as you follow the terms and conditions of probation, you will be on probation for 5 years or less if you do well. We will shorten it. There will be terms and conditions of probation, which are normal and customary for this type of offense. Plus, you shall be assessed a fine of $500. Please make sure you follow these terms and conditions of probation. If you fail, your probation can be revoked. You can then be found guilty, which would only take a minute. And you could be sentenced up to 2 years in the state jail. And that's almost day for day. So make sure you follow all of this. And if you do well, it will be shortened to up to a third of the time, for a year and a half or less. And is there anything else?
No.
Okay. Please see the probation officer and do well on probation. There's that. Darren Woods.
Ready.
Darren Woods.
Just want to make it. It's very.
Come on up to this lady, please, sir. She's going to swear you in right there. Thank you.
Thanks. So I need for me. You swear or affirm to tell the truth, the nothing but the truth, so you got it. Okay, you got your right thumb print, right thumb. Yep. The whole thumb. Okay, and then place it flat on the box right there. Okay, get up one more time. Okay, and then right outside the box right there. You go stand in front of the judge.
You're Darren Woods, and you're here with your attorney, Mr. Dusler, and the state's attorney is going to be present. Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
Yes, sir.
So he's an habitual felon here. What are we doing?
Count one.
Just one?
Yes, sir.
I guess there's a good reason for such benevolence because you're looking at a minimum 25 years in prison. Why would we go below that? I know there's a good reason. I don't know what it is. Somebody speak.
Yes, sir. Yes, sir. There's a good reason. We just felt that under the circumstance with the allegations here that he was not necessarily in a proper mental state at the time. It probably would not have happened. Otherwise, we feel like this is appropriate.
Pick it up. I read this probable cause affidavit. Does everybody agree? It's very disturbing.
It is. And
He
I,
threatened to kill people. The police officer. My goodness. He's a habitual felon and we're going to lighten the load?
well,
I mean, whatever, we open the door for one, we open the door for everybody. What's special about him? That everybody's going to be able to walk through the open door for. I
well,
mean, how can you
again,
threaten to kill people? And then as an habitual felon and then mitigate any punishment. And see, he'd be at my house to sexually assault him and his wife.
again, this occurred in a police car after he had been arrested. He
Yeah.
felt like he felt like he had been wrongfully detained at the time. He was not.
So quite naturally threatens to kill and sexual assault.
He was
people.
not in proper state of mind, and he said.
What does that mean?
He
I
said
don't
those.
understand.
He said
Was he-
those
Was
things.
he insane or not?
No, sir, but he said those things out of anger at the time for being picked up when he didn't realize, he didn't believe that he should have been stopped. And he didn't intend to, he didn't mean to.
How do you know that?
We,
I know you're advocating, but he said what he said.
Yeah.
He certainly intended to say it,
well, a lot of people say things in anger. My
Thank
wife threatens
you.
me all the time in anger,
but
and she means it sometimes.
has she ever said this to you? To kill you or sexually assault you?
Maybe the former part.
No, I know her. She wouldn't do that.
Anyway, we feel like this.
It would be in jest anyway.
Yes, sir.
Not that you don't deserve a good finger pointing by the wife sometimes, but no, this is very disturbing, especially somebody who's looking at habitual felon status. My goodness, you don't threaten people. They work for you anyway. The police work for you. You might as well threaten yourself in the mirror. Burglary of a habitation and then robbery. That means convicted of a violent crime.
So Judge just muted himself. I'm going to see if we can push past that. Hang tight. Hopefully we don't lose too much of this.
Be heard, and I want to know what the victim has to say about this proposed sentence. They have a voice with me. Do you understand?
Yes.
You have to speak out so she can hear you, sir, and put it in
Yes.
the radio. You're nodding. Speak out. Yes, yes. Okay, good. That's all.
He's
That's
not,
all I
he's
need.
not going to make a decision today.
Yeah, I'm
We're
gonna
gonna come back in a couple of
We're
weeks.
going to come back in 2 weeks, and I want the victim to be heard. So I want his input in my decision, which is what the law states should be done. Just not you. It's the victim is also the person who is harmed.
I know, I was just saying, if you gave him a chance to speak, you would steady talking instead of listening.
In 2 weeks.
You're held in contempt of court, Mr. Smart Alex.
Whatever you say.
Yes, sir. Yes, sir. And that's what it is. That was abusive and it was inappropriate. And only one of us can speak. You continue to be rude. You will be held in contempt, sir, and we'll take you up later. Thank you. And if it was a crime for being rude, that'd be another offense.
Frankly, friends, I think that's a good place to leave it for today. Only a few minutes left, so we'll cut it a little bit early, but I can't imagine a better ending for today than somebody being held in contempt. Okie dokie, friends. We'll be back tomorrow morning at 9 a.m. Eastern, 6 a.m. Pacific, a half an hour earlier if you are a channel member. And yeah, go have yourselves a good day. Look forward to seeing you tomorrow. Hope you had fun today. Take care. God bless.